your Lordship's kind permission, I make a mention for urgent listing of a writ appeal, my lords, where the Bangalore Metro Rail, your Lordships may recollect this matter, regarding this airport line, there was some dispute regarding the compensation amount that is to be paid. In fact, there was an undertaking before the learned single judge that the package compensation, if given, possession would be handed over. That was reiterated before your Lordships on 24th of January. Now, I'm told, my lords, they're interfering with the development work. If they have a dispute with regard to the compensation, they can work it out, which is what your Lordships had also noted. But to stop the development work, in fact, my lords, the Metro Rail wants to inaugurate the airport line at the earliest. Now that work is being stalled. So subject to your Lordship's convenience, sometime next week, any date next week, if not only 23rd, the learned AG is not available.
It is a writ appeal.
Writ appeal. Acquisition was quashed, but while quashing the acquisition, the undertaking of the writ petitioners that they would hand over possession if the package compensation is given to them. So now, my lords, that amount, in fact, the
Matter where amount was.
Yes, but amount is now being disputed. Of course, that can be worked out, but the work should not be stalled is our only apprehension.
22nd.
22nd, grateful.
Lord's kindly.
What is the urgency?
Urgency is that, my lords, the property is a house, residential house, my lords. It is not in a habitable condition, my lords. Have made a representation to the respondents. They have not considered my representation. So for the change of revenue entries, my lords.
29th.
Your Lordship, this is a commercial appeal, my lord, wherein the commercial execution arrest warrant has been issued against the appellant in this case, my lord. Hence the urgency, my lord, it may be taken up tomorrow, my lord.
After vacation.
My lord, it's coming up on 3rd May, my lord. Any date before that, my lord. Before vacations, my lord. There's an
Coming up for?
My lord?
Coming up for?
3rd May, my lord.
What?
The execution case.
Take time in that.
My lord, arrest warrant has been issued, my lord, without even issuing an arrest notice in this case, my lord.
Well, second May. Yes, Mr.
Lords, I am entered in a joint development agreement. Filed a petition under Section 9 of the Arbitration Act. The court will have rejected it. In fact, the developer is selling away my flats also fallen to my share, your lords. At least somewhere my request is the end of
10th of June.
Serial number.
Eligibility criteria in a tender has been rejected. Was challenged before the learned single judge, my lord. He has dismissed the writ petition. Filed the writ appeal, my lord. The urgency is that, my lord, I cannot participate in the tenders at all, my lord. That is why any day before the vacation.
24th.
Please.
Serial number 15. I got some personal inconvenience today.
15. A delay. Will you issue notice?
Yes.
There is a delay of 186 days.
Yes.
You will issue notice. Notice returnable on 25th of June.
To commercial appeals or admission matter to commercial appeal.
My lord, serial number 37, contempt does not survive for consideration, my lord. It may be permitted, disposed as withdrawn. Filing a memo with the complainant's email permitting me to withdraw.
Learned Advocate Mr. Akshay Kumar.
Please, ma'am.
For the complainant files memo. Taken record memo dated 16/4/25, which is taken record. It is stated that the contempt petition does not survive for consideration and that complainant has sent email dated 15/4/25 to instructing learned advocate for the complainant to withdraw the complaint. Permission is granted.
With your lordship's kind leave.
Contempt petition is dismissed as withdrawn. Yes, madam, one by one.
Well, it's my writ petition was dismissed for not complying with office objection, my lord. I have filed a recalling application, recalling the order, my lord.
After vacation.
With your lordship's.
26th of June, yes.
Number 21.
21. 21.
I seek for a short accommodation.
What is it about? That helmet, child,
With your lordship's kind leave, serial number 94, my lord, is the
it
matter
will go
relating.
to after vacation. The request of learned advocate Miss Bhavna, on behalf of the petitioner, I must stand over to 26th of June.
With your,
My lord, I have,
Serial number 82, I pray for a week. There are 4 writ appeals, 2 we have completed, 2 more we have to complete. 4 connected writ appeals.
82 at the request of learned of the appearance, stand over to, it will go to 23rd June.
my lord,
With
serial
your-
number 13, my lord.
With the lordship's kind leave, two commercial appeals, my lord, for admission. The urgency is this. The appellant, my lord, generates the civil score. Now, in a commercial dispute between the plaintiff and the defendant, borrower and the bank, direction is given to me, my lord, to restate the civil score of the borrower. To restate the civil score of the borrower, my lord, it's an automatic process. Now, the matter is before the commercial court on 2nd of June, my lord. Any date before that.
10th of June.
Serial number
With your-
32.
My lord, I have filed a recall application
Which one?
in contempt petition.
Serial number?
Contempt petition.
Listed today?
Not just, I am filing a memo.
Recall no urgency.
To hear,
No urgency.
to
20
hear, my lord.
Serial number,
Recall no urgency 20th June.
serial number
Any date
65,
may
my
be
lords.
given.
It is given 20th June.
Serial number
Any date
65, my
may-
lords. Pray for a week accommodation. Serial number 65.
65. Stand over to 30th June.
My lord, serial number 68, my lord.
My lord,
Yes, madam.
with your lordship's kind leave, serial number 94 in today's list, my lord, it's the election matter regarding the Bangalore Advocates Cooperative Society, my lord.
Hmm.
There is an urgency. The results of the election have to be declared. I have sought for modification of the interim order, my lord.
Hmm.
It may kindly be taken up at 2:30. Please, my lord.
Yeah,
94, my lord. It is listed for final hearing today
What
also.
is the urgency?
My lord, the results for the post of the treasurer, the elections are held on 9/8. It has to be declared. I have sought for modification of the interim order. I have filed an application.
What is the urgency for declaration? of
My lord, urgency is this. I have succeeded in the writ petition. Due to the interim order of this honorable court, the results could not be declared. Though election is held on 9/8 itself, my lord.
We'll see. We'll try to take up.
Serial
Please, my
number
lord.
62, my lord, is a transfer.
serial number 13, my lord, 4 weeks time, my lord. 13, 1-3, my lord.
13. Yes,
4 weeks time, my lord, after vacation, no urgency, my
at
lord.
the request of learned advocate. Miss so and so for the appearance, stand over to 1st July.
My lord, serial number 24.
BBMP has issued a notice. BBMP has issued a notice demanding 7 crores as improvement charges.
Little loud. Mic is there. Mic is here.
BBMP has issued a notice collection of improvement charges of 7 crores, my lord. I challenge that before the learned single judge, my lord. Same has been dismissed. I filed a writ appeal. I filed a writ
What is
appeal.
the urgency?
Urgency is that, my lord, it's a pharmaceutical company. BBMP may take coercive steps to recover that money, my lord.
16th, 17th of June.
My lord, serial number 24, my lord.
Yes,
Serial number 62, my lord.
60.
It is a green matter transferred from Dharwad Bank. Erroneously, they have classified it as GMRES. So kindly be listed in green matters.
So what do you want?
62, it may be listed along with green matters. It's at 62, we don't get hearing, my lord.
Which one? Which matter to be listed with this matter?
Serial number 62.
Correct. What is to
Green
be?
matter transferred from Dharwad Bank, my lord. They have listed, they classified it as GMRES. Erroneously, that's why it's coming at the end instead of green matter.
We are not able to understand.
My lord.
Explain to the court officer. Yes.
My lord,
My lord,
Just understand what the council is mentioning. Yes.
Contempt petition is not maintainable. Need to withdraw.
Which one? You want to withdraw?
Yes,
All right. Tomorrow at 2:30.
my lord, serial number 24, my lord.
20.
24 and 24.1.
Hmm.
In 24, I am the petitioner, 24.1, I am the respondent.
engaging a senior counsel. Time may be given.
Hmm.
24 and 24.1.
So what do you want? 24?
I will inform opposite.
You want time?
I'm the petitioner in 20.
You want time?
Time.
2nd July as requested by.
2nd July.
My lord. Serial number 68,
My
your
lord.
lordships.
Serial number 66. I appeared
Number?
66, Lord.
66.
Yes, sir. Appeared for appellant. I kindly request for 2 weeks of accommodation, my lord.
At the request of law, what is your name? So and so for the appellant. On behalf of the appellant, raise for time. Send over to 3rd of July.
Your lordship, serial number 68, your lordships.
As requested. Everywhere it is as requested.
Your lordship, serial number 68. It was originally listed by your lordships on the 12th of June, my lord. It has come up in today's list. My request is I'm for the appellant, my lord. It may be taken up on the 12th of June.
68 as requested by learned of the appellants to be. $68.1. So don't just cancel this one. So all matters 68 will go to which date as requested by learned appellants? 10 over to. When do you want?
Well, the 12th of June, your lordship had directed earlier.
As requested. Yes.
Much obliged, my lord.
My lord, may I make one submission? My lord, yesterday my lord was pleased to hear and reserve a matter with regard to withdrawal of prosecution, my lord. My lord, while giving the list of citations, my lord, the second volume not given, the first volume. I'm obliged.
Give copy to other side. Hell, where is it?
Contempt matter, serial number 1. Lloyd first.
Order dated 20 March 2024, minutes. Till date, minutes, they have not implemented. The direction is that minutes, within 3 months they need to.
Notice written in 24th June.
Serial number 2 to Sundaresh HC.
I appear for complaint, my lord. As per unnecessary, again, my lord,
24th June. Notice.
Serial number 3 to BC Venkatesh.
Lord, the direction, my lord, is at page number 17. To effect Kata, my lord, within 6 weeks. But we given a presentation on the 10th December 2024. Page number 17 is the direction.
24th June.
Serial number 4 is Sumana Baliga.
It's similar to that of yesterday's rounding off of the marks. The batch is listed on.
When yesterday's matter is kept?
23rd lot.
3rd June.
Notice and handsome.
Petition PL, serial number 5, Mr. George Anthony Cruz.
For my noble lordship, this is a matter pertaining to running illicit liquor shops in the name and sale of wine shop, that too inside the government bus stop, committed lot of nuisance. The respondent number 1 to 4 are supposed to maintain the public health and public safety. It is not in violation of this. It is given a wine shop.
All right, notice written alone.
My lord, mandamus sought, my lord, to enforce a legal notice.
Liquor shops are set up behind the bus station.
Yes, but mandamus to, my lord.
Nobody will go to bus. Nobody is embark the bus. Notice written alone. Just we'll see what to do. Written alone. 18th of June.
Obliged.
Serial number 6, so PL, Abhimanyu Arjun.
Maharaj, appear for the petitioners who are residents of a village, Maharaj, in Kodagu district. The specific allegation, Maharaj, is that respondents 7 to 9, they run an RMC, that is ready mix concrete and other similar activities, Maharaj, all their effluents are being discharged into the river, and otherwise air pollution also is being.
Having heard learned senior advocate Mr. Vikram stand notice to the respondents.
May I just one request, although our interim prayer I won't press on at this stage, my lords, to shut down the industry. Could the pollution control board, my lords, inspect the place, because my lords, it's an orange category industry. Let them inspect and file a
I appear
report.
for respondent number 6, my lords. I take notice, my lords.
19-6, learned advocate Mr. Mahesh Chaudhary for number 6,
Yes,
pollution control board accepts notice. It will be open for the respondent pollution control board to inspect the site.
Inspect them.
Open.
Seal number 7.
For respondent numbers 2, my lord.
Does it survive? What is the?
For respondent number 10, my lords. And for respondent number 10, matter is regarding to the pothole, my lord. The last date, respondent number 2, BBMP has said that they will file an affidavit.
My lords, we'll take a couple of more days. My lord, it's ready. We just need to get some signature. Because of the leave last week, it is getting delayed. Lordship in time is a very short accommodation.
Wait for learned advocate. Wait for learned by learned Mr. Pranjali for the BB. Further time is granted to file affidavit as requested. Stand over to say 23rd of June.
3rd June.
Seal number 8 to Vijay Kumar.
I pray for a short accommodation. I filed an application to recall an order.
Filed an application to recall the order.
What has transpired is the petition was disposed of, subsequent to which an order was passed, contrary to the original directions. So I have filed an application to recall the order.
Contrary to?
Contrary to the original direction order of disposal. So I would like to address arguments. I pray for some time to address arguments on the application.
As requested
One
by
submission, ma'am.
the applicant.
That's one submission.
Applicant will recall stand over to 9th of July. Yes.
Well, this case filed in interest of public by the citizen of our state. But after holding detailed inquiry by the state court, and the Tahsildar and the Assistant Commissioner, the Deputy must hold a spot inspection. The 11th respondent enclosed the government land worth of rupees more than 100 crores. And after conducting the detailed inquiry, the Assistant Commander, the Revenue Officer, submit the report before the Honorable Court. After gone through the order passed by the Revenue Officers, this Honorable Court directed dispose of the matter with a direction to the Tahsildar and the Revenue Officer to Deputy Commissioner and Assistant Commissioner to demolish the building and to take position to the government.
That order has been stayed, my lords. It's contrary to survey records. It has been stayed.
What happened afterwards, my lord? My learned friend, the 11th respondent, filed a writ petition before the learned single judge, obtained the interim order of stay. By virtue of that, the revenue officers cannot take any action by virtue of the application. This is the situation at present, my lord. Hence, my lord, it is better to dispose of the matter in the interest of public, my lord. This is my humble request.
It is already disposed of.
Sorry, ma'am.
It is already disposed of. Yes, by recalling it.
That is by great respect, I am submitting. My lord, the 11th respondent is very powerful. He is a politician, and there are so many background behind that person. But they suppressed the fact before the learned single judge, order of this division bench order, and obtained the interim order of stay. By virtue of that, they are keep quiet. The officers are keep quiet. They are not taken any action. In the interest of public, kindly take up this matter next week, any date, because the matter is very serious. With great respect, I am requesting the Honorable Court.
9th July.
9th July, madam. That is too late, man.
There is no urgency.
My lord, what happened?
Or your application, Mr.
That's correct, my lord. My lord, I have filed a petition Right, on the basis of that, my lord, this honorable got very clear direction. Your Lordship can see for a moment, last order. It's very clear. They have enclosed the property of the government and construct the building. And they are not, now they are selling the property to the various persons, my lord. You know, Allah, correct, I understand, my lord, but
That order stands until it is recalled, correct?
Allah, what happened, my lord? Suppose, my lord, if the developer sold the property to the innocent people by investing a crores of rupees for a flat, they will become sufferers, my lord. That's why I'm requesting.
I'll see.
Allah, at least, my lord, your lordship, with great respect, I'm submitting, my lord. At least June first week. June first week.
Yes, next.
CC number 9, Mr. Manu Prabhakar Kulkarni.
My lord, this is a petition, my lords, challenging the constitutional validity of an act expressly enacted expressly for the purposes of.
Anybody wants to file further pleading?
Written notes are also filed.
You have filed it?
I have filed, my lords, written notes.
Written submissions.
The impugned legislation, my lords, is at page 55.
Matters being heard.
An act to provide protection to religious structure on a public place. Page 55, my lords.
My lord is hearing the matter, my lord. My lord is hearing the matter.
It is already heard.
No, my lord, I have to get the learned advocate general, my lord. That's the reason why. If my lord is hearing the matter, then I'll just get him.
Keep it back.
Oh, yeah.
Please.
Yes, yes. Ask her.
CC number 10, it's a green bench matter.
Enter 9 series kept by my lord. Enter 9 series, there are 7 matters. I am one of the applicants. 9 to 9.7, all kept by my lord.
CC number 10, it's a green bench matter. Mr. Nataraj Ballan.
I appear for the petitioner. Lord, petitioners, my lord, are the residents of village in Kolar district, my lord, which is Medihala. Lord, their primary source of income is agriculture and cattle rearing, my lord. Lord, the respondent number 7, my lord, seeks for a quarrying license. Lord, in the adjacent gram panchayat, which is falling on the boundary of this land, my lord, of the petitioner's land, which is survey number 42, where he is seeking for.
Notice is around 24.
I will take notice for respondent number 1 to 5, my lord.
Government advocate, Mr. Additional Government, Harish, access notice on behalf of 1 to 5. 24 June.
CC number 11, S.Y. Shivalli. Lord. In this matter, Lord, the petitioner has challenged the order of revisional authority that is produced at Annexure D dated 26th April 2024. Lord, revisional authority has rejected the order passed by the competent authority, holding that there is delay of 6 years in filing revision petition. So there is no provision to entertain the revision petition and to condone the delay. So against which, Lord, the present writ petition is filed. Lord, similar writ petition was filed, in which lordships have already dismissed identical matter, but keeping open liberty to the petitioner to approach the competent authority, relying upon Rule 8B. Lord, this is the order, Lord, which lordships have already passed, rejecting the writ petition. But
where it is not on delay.
Please note, the delay on the ground of delay of 6 years, 2 months in the instant case.
Sure.
And the identical matter, lordship already dismissed.
Here, where is that page 37 is the order? Where is the delay aspect is mentioned?
My lord, page 60. Page 60 annexure D, my lord, which is at 54, page 60. First line.
Page number 60, last, first para, last 2 lines, my lord. First para, last 2 lines. Revision petition is filed belatedly after lapse of nearly 6 years, 2 months. The petition cannot be considered and the following order is passed. Accordingly, the revision petition is dismissed. The similar matters lordships have already dismissed. I can't suppress.
What was challenged?
Not challenge also annexure C is the,
Page 38 order.
please.
What was challenge was page order at page 38.
Yes, my
Please
lord,
note.
page 37.
37, yes. So it was order passed on which date?
17 to 2017, Lord.
So 6 years.
Please, this was the challenge in revision petition in the year 2024, Lord. So the authority, Lord, dismissed it on the ground of, but fact that there is not my application came to be saved in view of Rule 8B, which came to be inserted in the 2023, under which my application is eligible to be considered. Not the endorsement issued at annexure C, not the fact that it was not at all supplied to the petitioner. But however, the reason was not assigned the filing revision petition. Revision petition, not the revisional authority, not dismissed it since no reasons are assigned, one thing, and there is no provision to entertain beyond a 90 days period to on two grounds. And that apart, there is one more provision, one more ground that only 1 acre is involved in the instant case, but as per Schedule 2A and Rule 15A, 2 acres is required. So that is the ground on which lordships in the identical matter.
What is wrong?
Identical matter was dismissed, keeping open liberty. So this is also identical matter, not a mess.
We don't know it is identical, right?
My lord, the reasons given in the revision petition, my lord, in the revision order is very clear.
Lordship's order, Lord. Referring Rule 53. Kindly take para number 4 of the Lordship's order, page number 4, Lord. Against the order dated 17/2/2017, the revision application was filed by the petitioner, which was delayed by 6 years, 3 months. The revision was filed under Rule 53 of Karnataka Minor Mineral Concession Rules 1994. Rule 53 was culled out. Thus, the rule making authority provided a period of 90 days from the date of communication of the order to be subject to revisional proceedings. As per proviso, if the applicant is able to show sufficient cause for not making the application within the said period days, further grace period of 30 days is available from the date of expiry of the said period. While dismissing the revisional application on the ground that it was beyond the limitation, the revisional authority observed that the revision petition was highly belated and therefore was not maintainable. In addition to that said aspect, it was noted by the revisional authority that as per Rule 15A1 of the said rules, no quarry, lease or license shall be granted within the extent of less than the minimum as provided in Schedule 2A of the rules, and that such extent in respect of the instant mineral is 2 acres, implying thereby that if the application is made for a period for a long land comprising less than 2 acres, it is not liable to be considered. In addition to the above subject, the further aspect considered by the revisional authority is that proposed stone quarry area is coming within 10 kilometers of eco-sensitive zone of Ranebennur Krishna Mruga. While the observations are made by the revisional authority, in the aforesaid aspects also what is waived by the revisional authority is the delay of 6 years and 3 months, which rendered the revisional application incompetent in law. Learned advocate for petition argued in vain that the petition applicant was not aware
That will take into account the last paragraph of this.
last para, please. Para number 7. Para number 7. Please. Only dates are different. Survey number only different. Rest all is identical. Not impugned order as well as the competent authority order identical dates. Only survey number 74. That
all identical.
Almost order is high.
Survey number is
74 in the instant case. The previous case 73. There also 1 acre. Here also 1 acre. Petitioners are different.
Date of orders will be different.
Date of order change.
We'll pass.
Please.
Number 12, Shrimati B. Vidyalata.
This is a challenge made to Rule 32, my lords. Similar matters, my lords, which were dismissed by this Honorable Court is pending before the Honorable Apex Court, where an interim order is granted. Based on that, my lords, this Honorable Court has also been granting interim orders. My lords, that is at page 102, my lords. Rule 32, my lords, where the Patta landholders of Old Mysore region are also entitled to seek license, my lords, that is challenged, which is a matter pending before Apex Court, my lords. 102. 103, my lords, is the para 7, my lords. 103. Your lordships have permitted us to continue quarrying operation. Yes, my lords. We have all permits, my lords, have enclosed all the permits.
Two prayers are made in this writ petition. First is to declare that Rule 32 of the Karnataka Minor Mineral Concession and Duplicate Amendment, bracket over Rules 260, amended by notification dated 12/8/16, is unconstitutional. The second prayer is to direct the respondents to issue mineral dispatch permit to transport granite quarried over the Patta land in survey number 33/1 capital A and 33/8 of Chinnambali village, Kiligere Hobli, Nanjanagur Taluka, Mysore district. Learned advocate Ms. B.V. Vidyulata for the petitioner, whom in course of the submission pointed out that the text of the present petition is similar to Writ petition number 338 of 25, in which also the validity of same Rule 32 is under challenge, and that the court has, while issuing notice, granted interim relief also. In that view, notice to be heard with Writ petition 33 of 2025. By of interim measure, it is provided that paragraph. By of interim measure, it is provided that petitioner shall be permitted to carry on the quarrying operations, and the respondents concerned shall issue permit on payment of royalty as per the existing notification, provided the petitioner possesses the quarrying plan and environment certificate.
We have both.
Environment clearance certificate. When that matter is coming up?
10th of June, my lord.
Learned additional government advocates of the states that the other cognate matter is slated to be listed on 10th of June. Accordingly, notice in this petition shall be returnable along with the above interim leave.
My lords, if it is not too much to seek indulgence, serial number 89 is also similar matter.
Similar matter.
Yes, my lords.
Same order.
Same order. Only the village and the survey number is different, my lords. Rest of
Same order.
89. I'm sorry, my lords. Grateful.
Office observance in 89. Office observance will be removed before the next day.
Yes, my lord. I'll do that immediately.
13 is urgent. Number 14 is a state appeal.
So delay.
14, my lord, there's a connected matter, my lord, in writ appeal 1484 of 2024, my lord, that is listed on 25th April. If your lordship can have this, my lord, the respondents there can accept notice in this matter
Notice
also.
returnable on 26th April.
25th April.
15 is urgent. Number 16, Mohammed Tahir.
We have filed objection to the compliance affidavit.
Appeared for the
Elections
complainant.
have been scheduled, my lord. As per the calendar of events, election process have been begun. They have been doing all this thing, my lord. June 16th is the election.
My lord, the government has filed an affidavit here, my lord, on previous occasion on 17th February 25, furnishing the schedule of events, my lord. As per the schedule, election is scheduled on 15th June, my lord. Yesterday, we have filed one more further compliance affidavit, my lord, reporting the progress in the matter. We are on track for conducting the election on 15th June, my lord. All necessary action is being taken, my lord.
Your lordship may kindly peruse the order dated 13/12, your lordship's order, my lord. In the contempt petition.
The contempt.
13/12. 13/12/24. In the course of hearing of this contempt petition, learned advocate general so and so, appearing for the respondent state, made a statement that the respondents are inclined to comply with the order of the division bench regarding holding of election of Mysore Chamarajanagar District Central Cooperative Bank Limited expeditiously. In any case, election shall be completed within time, not later than 3 months from today. Actually, this was their undertaking, but your lordships made it as court order. After this, now they file an affidavit saying, we have to comply with Rule 13D2A. Therefore, we are holding election in June. In the meanwhile, the registrar, who is a party to this contempt petition, passes an order to amend the bylaws of the Mysore Chamarajanagar DCC Bank so that election cannot be held. He makes all those changes. After getting that order and amending the bylaw, they file this compliance, this thing. A specific actually it was undertaking by the learned advocate general, but later your lordships made it as court order. It's actually aggravating contempt.
Today, writ appeal is also there.
Please. Lord, lordship can have it in the first week of June, my lord. We have filed an affidavit reporting the progress that we have made, my lord. The election is scheduled on 15th June, my lord. If the matter can be taken up in the first week of June, my lord, we will report further progress, my lord. We are on track to conduct the election on 15th June, my lord. That is my respectful submission.
So what is the writ appeal? Let us.
Writ appeal is disposed of with a direction. Appear for the election authority.
The order in the writ appeal may kindly be seen, my lord.
The writ appeal will not serve.
Writ appeal is a disposed of matter. They had filed an application for extension of time, therefore it is put up. That is the order which is violated. That is the order of which we are complaining of the violation.
And we'll hear after it.
Please,
Contempt.
Please.
Learned advocate Jay Kumar Patil for the complainant petitioner highlights the order dated 13/24 passed by the court in which statement made by learned advocate general the elections to the Mysuru and Chamrajnagar central government will be completed in time not later than 3 months. Date of the order. Learned advocate the respondents. Who are with it? What's your name?
I appear for the election authority. I appear for Mr. Kiran Kumar.
Professor Ravi Verma.
Professor Ravi Verma Kumar for the election commission.
Please, ma'am.
Election
Stated that the election process is announced. Elections are, what is the stage?
Now
No,
delegate
Lord.
form have been received.
Is underway.
Yes, yes.
Timetable is produced?
Yes, my lord.
Yes.
We have filed in the affidavit.
We have filed an affidavit yesterday, my lord.
The timetable of the election.
My lord, that is available in affidavit dated 17 February 25.
Date of election would be 16. And that the final list of voters will be published on 25/5/25, and the date of election will be 15/6/25. Full stop. Learned advocate for the petitioner, however, would emphasize that the elections are required to be heard within 3 months from the date of the aforesaid order dated 13/12/24 as the statement made. Full stop. That the proceedings be put up for further hearing.
Please.
For hearing.
Please.
That the proceedings be put up next on 11th of June.
After 15, my lord, after the election. Anyhow, 15th, the election will be over, my lord. After that, your lordship may kindly hear.
a week later. A week later, matter can be.
17th.
Very well.
Please.
Please.
I said that we not like. Yes.
Commercial appeals, SC number 17.
That's it is a section 37 appeal, my lords. That's annexure B is the arbitration award. The arbitration award is in my favor. The issue is that, my lords, I had invested a next sum of rupees, my lords, 40 lakh rupees with ICICI Bank, which is respondent number 1. As who was dealing with security, they were stockbroker, my lords. They had appointed an authorized representative. Now that person, my lords, committed a fraud upon me and the bank. And my lords, swindled my entire money, and my lords, I was left with 4,000 rupees. May I take my lords to page number 46, my lords. 46. Paragraph number 8, my lords, for a moment. Page 46, my lords. Page 46, paragraph number 8, my lords.
You are for the bank.
I am for the claimant, my lords. I was for the original claimant. The arbitration award was in my favor. That's on merit. It's been upsetted in the section 34 petition. My lords. May take only 2 paragraphs of this petition. 8, my lords. The apparent arbitral tribunal panel, in concluding that there is contributory negligence on the part of the applicant, is having compromised password and other credentials with the AP. AP stands for, my lords, authorized person, and reposed blind faith and trust on AP in carrying out buy, sell, trade in her account. The arbitral panel also finds fault with the applicant in having not verified the contract notes, demat statement, SMS alert sent as and when trade is carried out and periodically. The panel of appellant arbitrators also find fault with the applicant in having not raised alarm with the respondent. Well, that's paragraph number 11, my lords. At the bottom, page 46, paragraph number 11. There's a master circular which has been referred, my lords, by SEBI, which says that, my lords, the stock shall be responsible for all acts of omission and commission of the authorized person, and all acts of omission and commission of the authorized person shall be deemed to be those of stockbroker. ₹12,75,000, my lords. Now, my lords, the interesting part is I make both the stockbroker as well as the authorized party, authorized person, my lords, at page 39 as parties to the dispute. They're not, notice has to be issued. My lords, I'm also requesting, my lords, a stay, my lords. The reason being, I can explain that, my lords. The arbitration award is passed on, my lords. Arbitration award is passed on 23/3/2023, my lords. But, my lords, the section 34 petition has been instituted on 15/7/2024. 23, my lords. My lords, it's beyond the even statutory permutation, my lords, under section 34. Now, my lords, even on that ground, my lords, the court could not have entertained section 34 petition at all, leaving apart the merits of the case.
But will not, will amount to revival of the award.
My lords, they've already deposited the amount before the arbitration tribunal. It's not the case that, my lords, they are not responsible. In fact, my lords, even in section 34 petition, it is clearly observed, my lords, that it is their responsibility, but it's only because I had shared my password, which, my lords, I have to share. If somebody is appointed as my representative, I have to go ahead and share my password because they have to operate on my behalf. Now, my lords, and even on the jurisdictional part, my lords, the section 34 court could not have even entertained the entire petition itself.
If we grant any relief, it will amount to revival of the order, and in turn will amount to granting of the appeal at this stage itself.
My lords, may I request one thing then? May I request at least allow me to withdraw the amount subject to No, I stand corrected. My prayer was I've already withdrawn the amount. Let there not be any interest consequences, my lords, at least in case. Now, my lords, today they will go for execution. My lords, today they'll be in a position to go for execution to recover that money back from me. I've got the award in my favor. Let them not precipitate on that issue, my lords.
Deposited the amount.
My lords, yes, I have withdrawn the amount. They have deposited the amount. I have withdrawn the amount.
Where you have stated?
My lords.
Stated in the
yes.
Or learned education for the by impugned judgment in order. Learned 87 additional citizens and citizens Bengaluru allowed the petition filed by the petitioner respondent hearing under section 34 of the Arbitration and Concession Act. Consequently, again, award passed by the appellate tribunal dated 23/3/23 came to be set aside. Full stop. Notice returnable on 24th of June. Full stop. As per the original award passed by the arbitrator. The appellate tribunal awarded rupees 12,77,858 to be paid to the appellant. Full stop. In course of the submissions come while praying for stay, while praying for interim relief, it was submitted by law and record to the appellant that the awarded amount is already deposited.
So that's they've deposited and we've withdrawn it, my lords. The total amount deposited is 12,75,000.
And that the appellants have also withdrawn the amount. Full stop. On the next date of hearing of the appeal, learned advocate for the appellant shall produce the proof of deposit.
Yes.
On the next day, you produce the proof.
Yes, my lords.
Proof of the deposit.
And withdrawal, my lords. We withdrawn it also.
Withdrawal of the amount. Full stop. In view that the statement is made that the awarded amount is deposited and has also been withdrawn by the appellant, by aid interim it is directed that any precipitative steps or any steps in reversal shall not
Or to recover that amount.
in reversal
3 months.
to recover the amount
Yes,
shall not
yes.
be taken till the
Great.
next day. Shall not be taken, full stop.
Seal number 18, Mr. Kapil Dixit.
My lordship, we have sought for the set aside the order of the IA number 12, that is in the annexure E, my lordship. The impugned order is like annexure number A, page number 25, and the operative
notice
portion is
written
on page number 34. This was the restoration of the suit, which was dismissed on the 21/10.
7 days delay.
Yes, my lordship.
So-
There is a 7 days delay because we have filed the writ petition on the IA number 12. We sought the liberty before the single bench to withdraw the matter and file the appropriate forum. That's why the 7 days, the delay was happened, my lordship.
So notice
My lordship.
in delay application, notice returnable on 18th June.
Seal number 19, PL.
For the petitioner.
Appear for respondent number 5, Your Honor.
Appear for 20 to 65.
My statement has been sent to the department. I'm awaiting the vetting copy to be filed before the court. Maybe immediately after vacation. So the pleadings get completed. Your Honor.
For the respondents, 10 out. It will go, no, 18th of June.
Much of
Seal number 20.
My lord, in this petition, the petitioner is challenging the consent for establishment issued by the Karnataka State Pollution Control Board. Respondent number 1, which is annexed on page number 56, my lord. The port of Karwar Port has proposed second stage expansion on Karwar beach. But all the documents, my lord, which they have given as reference, they mention it as Baitkol. Baitkol is 5 kilometers, nearly 5 kilometers away from Karwar. So there is lot of misrepresentation in the data, and they have obtained the consents, my lord. And this CFE, which has been issued pursuant to the order of this Honorable High Court, which has been placed as Annexure C, my lord, on page number 66, where the first CFE which was issued for this proposed expansion was declared to be illegal by this Honorable Court on page number 115, my lord, because the process of enquiry was not conducted properly. With the permission of this Honorable Court, I would like to read that paragraph on.
You are not appeal. Date is there. Or?
The earlier writ petitions, my lord, were filed challenging the project itself.
Yes, madam.
My lord, appearing for respondent number 1, my lord, will you take instructions and
My lord, this is pending before the Honorable Supreme Court in SLP 17213 of 2021, which is tentatively posted to 20th May 2025.
My lord, this is not pending, my lord. This honorable court judgment, which was delivered on 29th July 2021, was appealed before the Supreme Court by the same parties. Now, pursuant to this order, a second CFE has been issued by KSPCB. This petition is challenging this second CFE, which has been issued by KSPCB after this order, my lord. The pending case is not challenging that CFE.
Learned advocate Miss
Amulya Bhatt?
My lord,
Will
they have
take
not.
instructions, my lord.
What's your name?
They have not submitted their objections till date, my lord.
To file the objections. Time is granted. The petition to come up next on 1st July.
My lord, there is an interim order which I am seeking to stay the construction till the disposal of this petition, because they have not even filed for 2 years, my lord. It is a lot of time they have taken, and they are not appearing also.
Now you
And
file-
once they appeared and they said we have not received the copy, when thrice it has been served on them, my lord.
You file now, madam. When you will file?
After vacation.
Plus
My
you will
lord,
file
please,
on or
before vacation.
On or before 9th of June.
9th of June.
My lord, humble request for interim order, my lord.
It can't be granted. Let the reply
Because
be.
once this honorable court has, in the earlier petition, accorded the interim order of staying because they had illegally started it. Without even CFE, they had started the construction earlier.
No, interim order is refused.
21 is adjourned. Seal number 22, Mr. Mahendra SS. It's a green bench matter.
Don't try.
No, no, I know. It is what I plan to do. Yeah.
The decision of the District Task Force Committee.
Yes.
The decision of the District Task Force Committee seeking no objection certificates or the status of the land for the second time is questioned in this petition.
My lord, prayer 2 may be seen, my lord, the second prayer.
Representation.
We will consider it in accordance with law.
Then the decision has to be quashed.
No,
First,
no,
because
no, no.
for this reason, right, as of now, this District Task Force Committee is not there. That provision has been repealed.
Then my lord may have it after vacation, my lord. I'll file a
What is
complaint.
this resolution? 5824.
Lord,
This 5824 resolution of the task force. What is it?
Lord, in this matter, all the statutory requirements have been complied with. Despite the same, the competent authority placed this issue before the District Task Force Committee. The District Task Force Committee, for the second time, it is seeking, there is no provision. The District Task Force Committee is seeking the status of the land.
My lord, please see the reasoning at page 26, the second paragraph as to why, my lord, they are seeking for the report.
There is no provision at all, Lord. And they are seeking status of the land. Even assuming, Lord, your Lordship may kindly appreciate this. This decision was taken on 5/8/2024. Almost a year gone by. This is just to delay the smooth process. And moreover, they do not have authority.
I reply.
Very well.
And already sufficient time has been granted.
Lord,
It is almost 1 year for seeking status of the land.
So task force committee is asking you to furnish the.
Not us, Lord. There is a committee, Lord, consisting of the district commissioner, assistant commissioner, everybody. The members have to, Lord, submit the status of the land in question.
They are asking forest clearance.
Not forest clearance.
Then?
It is in a government land. No application was filed.
So what is the grievance?
The grievance is no objection has been granted by the revenue department and
Correct.
forest department.
So now what the task force committee is doing?
Second time they are asking.
That is what he is asking.
my lords, please see the reason why they are asking, my lord. We don't want to have multiplicity of proceedings. We don't want to have third-party interest. My lord, filing an application and seeking for its consideration as a matter of right. Filing an application.
Now, my lord, district task force committee is not in existence.
My lord may have this after vacation,
Lord,
my lord.
my
I'll file my
submission is
objections. My lord may
not in
hear
existence.
this matter. No, don't waste the time of the court. My lord may have this after vacation.
Now, the district task force committee is not in existence. That provision has been repealed. Therefore, my request is this may be remitted back to the competent authority, that is the senior geologist. Let him decide the application in accordance with law.
Why should we permit this overreaching the reasoning of the task force committee?
That?
Why should the authority overreach the reasoning of the task force committee, which wants the re-inspection or re-examination after 10 years?
My lord, we don't want to create any third-party interest. We don't want to have multiplicity of proceedings to see when that application is considered. My lord, we have sought for
even
this.
if their intention
My lord
is,
may have this after vacation. Filing of an application and then seeking, my lord, consideration of that application as a matter of right doesn't augur well. Even, my lord, the decisions of the Supreme Court is there to that effect.
may I make a submission. Even if their intention is clear, Lord, to assess the status of the land, it would have been done within a month.
My
Now
lord,
it is,
why? Why the priority, my lord? Can filing of an application means a matter of right?
these submissions are not substantiated submissions. Lord. It is
All
all
right, we
those
will
submissions made
substantiate it.
before the court. Now, my submission is, Lord, this decision was taken on 5/8/2024. Nothing has happened till now. They are sleeping over the matter, Lord. And there is, the statute prescribes, Lord, time-bound consideration of my application. Now this district task force committee is not there. The competent authority has to decide.
The committee is not there.
Not there. It has been repealed. Your Lordship may kindly see
Lord,
in
I'll
the,
file my
by the virtue
objection,
of
my lord.
this.
My lord may have this
So then
after
it is not there. It
vacation.
doesn't take away this.
My lord, I will explain that in my
Please.
statement.
Won't wash up this order.
Yes,
True,
yes,
Lord.
it doesn't.
My submission is the very placing is bad in law. That I can establish. Now, having placed it before the authority, they have taken right or wrong decision, Lord, on 5/8/2024. My submission is now they cannot submit the status before the district task force committee because it is not there. Now the competent authority has to decide.
My lord, that is his second prayer. It is exactly for that reason I said we will consider that representation in accordance with law.
We can say that if your representation is considered, then this order will automatically go.
My lord, it will be considered in accordance with law. That is why
Within
I
a time-bound
said.
manner, my lord, because
So now, who will consider?
My lord, respondent number 3. Deputy Director.
may I draw your last kind attention to 8.6, my lord, rule 8.6. This was in existence when the matter was placed before the district task force committee. Now it has been repealed.
By filing this petition. Resolution dated 5/8/24 of the District Task Force Committee, Tumkur District, as responsory hearing is called in question. Also, thereby the District Task Force Committee has invited fresh opinions from the Forest and Revenue Department regarding the application of petitioners for grant of core release. The petitioner wants this court to direct the competent authority to expeditiously consider the application in accordance with law and in particular under Rule 8 Capital B of the Karnataka Minor Mineral Concession Rules 1994 and Karnataka Minor Mineral Concession Inaugurate Amendment Rules 2023. Subject matter land is survey number 100. Situated at Kawal village. Kawal village. Not? Don't. Is Kawal village. AK Kawal village.
AK Kaval.
Kulur Hobli, Tumkur district. One of the prayer in the petition is to direct the competent authority, case number 3. Who is number 3? Deputy Commissioner, Deputy Director, Geology and Mines Department. Who considered the representation of the petitioner dated 13/4/23 expeditiously. Since the representation is pending and at this stage the authorities are the best judge to consider the grievance of the petitioner and further consider the case of the petitioner for grant of Quarry lease, the present petition is disposed of, without going into the merits thereof and without expressing any opinion on merits, by directing this one of the Deputy Director, Geology and Mines, to decide the pending representation. The Department of Mines and Geology and Mines to Tumkur, deciding the representative petitioner dated such and such 13/4/23 within a period of 8 weeks. Decision shall be communicated to the petitioner. It is so 22.1 also same article.
Obliged.
Obliged, my lord.
Number 23, it appeal Mr. Srikara PK.
Appellant. My lord, a challenge was made, my lord, to acquisition that had been made under the BDA Act. In that challenge, my lord, was in WP number 53576 of 2023. Your lordship will kindly see, my lord, the operative portion of that order, which your lordships will find. The final order. Now kindly turn to page number 236, my lord. That's the order that was passed, my lord, in the earlier writ petition on 6th of June 2006. May I trouble your lordship to kindly see the relevant portion of that order.
We're going to argue for merits, no?
At page number 380. The challenge, my lord, to the acquisition failed.
Hearing it finally. Finally.
Whatever they are.
Hearing it finally, my lord, because
I'm ready, my lord.
this matter had come up earlier on several occasions and request for interim relief was refused. Therefore, your lordship.
No, it's not refused. It's not refused.
Because you can see the number of times this.
I'm ready to make.
Yes,
Lord,
yes. I'm also
I
ready.
want to make my submissions. If your lordships are hearing it finally, my lord, I'm ready today. If it's a question, my lord, of interim order, I only want to point out a few things. I just want, my lord, I just want, my lord, the BDA not to alter status quo during the pendency of the writ appeal. This is all that I'm asking. Your lordships may kindly hear me for a minute as to why I'm asking for that prayer.
What is the subject matter?
No, subject matter, my lord, I tell you, lordships.
Clear heard?
Yes, my lord. Lordships had heard us. I think Mr. Holda appeared last time, my lord. And then he had made some submissions before, my lord. And then your lordships found, my lord, there was a person who's purchased it from them. There is an agreement holder who has come and filed a separate writ petition, a writ appeal before, my lord. They don't disclose anything to the learned single judge that they've actually transacted with this property which is acquired by the government. And then that other gentleman comes and files a writ appeal saying, I'm challenging that order as the person who's entitled to the property.
Can I make my submissions? My lord,
And compensation has been taken.
No, my lord, that is the point. That is where, my lord, the court, if I may say so with due respect, was misled. That's exactly what I want to point out. My lord, what was told to your lordship was that the compensation amount in respect of the acquisition of the appellant's land has been withdrawn by the appellant.
Not really urgent, then reopen.
My lord, let them not precipitate. But really what they're now doing, my lord, is creating, making sites and selling it. That they can't do.
Done, sir.
Well, 1 minute.
Done.
No, it's not. No, my lord. I'll point out to your lordship what has happened.
They are the
Please permit
allottees.
me to point out what has been done. Let status quo be maintained so that, my lord, the nature of the property is not altered. Otherwise, my lord, the whole thing will become a exercise in futility so far as the appellant is concerned. Can I point out what is the point I want to mention?
By the allottees, that we are already in possession of the property which is already filed on 9/3/2020.
Right, my lord, I understand, my lord, that is what that case was, that allotment has been made. That is why we came before the court. And now, my lord, kindly see, there has been no construction, nothing has happened to the property. Let the status quo be maintained with respect to the nature of the property. My lord, can I point out what I'm saying?
I have already allotted, my lord, and handed over
No,
possession to
that is the, if I may say so, with due respect, the fraud that BDA has committed in this case. Let me point out what happened, my lord. And there is a clear flouting of an earlier order that has been passed by this honorable court. And may I point out what the order was? Please be kind enough to turn to page 380. The order passed an earlier writ petition. And BDA has resolved, my lord, that this property is not required and it is being denotified. And in spite of it, all this BDA is doing. Well, there is much that requires to be said in this case on the conduct of the BDA. So may I point out page 380 for your lordships, my lord, that order in the earlier writ petition. Please be kind enough to turn to page 380, my lord, of the order in the earlier writ petition. May I have your lordship's permission to place it, my lord? All that I am now seeking is let status quo be maintained. Now BDA says I have allotted the property to somebody else. That somebody else, my lord, tomorrow will come and say I'm constructing a house. The whole nature of the property will change, and I ask myself, what is
allottees are already on record. They won't come back. They're already on record. My learned friend appears to the allottees. They were heard before the learned single judge as well. Before learned single judge himself, he was there. Court has considered all those questions and then said there's no question of
I
interfering.
will point out what the court has not considered.
Don't change the
That's all.
equities.
The allottees, lordships have to die.
Don't change the equities at least.
My lord, we are not selling the properties. We have been allotted with the property. We have demarcated our site.
That nobody, whatever is the existing, whatever status is available on the housing date, let it continue. That's all he wants.
Sure, that, my lord, our contention is that we would like to put up construction.
No.
As your lordship said, that could be permitted. But again, when we go back to the plan and approval authorities, that comes in where the writ appeal comes in our way. We are all put in a fix that even though the court, for a moment, if your lordship is pleased to take the findings of the single judge.
Can I make my submission? I am the appellant. If we are going into merits, I want to make my submission, please.
What is, court has already considered we are in possession of the property.
What is the
and
basic?
They themselves have admitted.
What is the basic controversy?
No, basic controversy. My property was acquired. A preliminary notification was issued, and the final notification was issued under the BDA Act for extension of a particular layout. That, my lord, was subject matter of a challenge by my client. That resulted, my lord, in, yes, my lord, the writ petition was dismissed. But while dismissing the writ petition, the court has issued the following directions. That is what I want to point out to your lordship at page 380. Not in this writ petition, my lord, out of which the present appeal arises, in an earlier round of writ petition.
What is this present order?
Now, present order, the learned single judge has not considered the crucial point as to the denotification. There is a direction that the BDA must consider our application for denotification. That has not been considered. Now, that point has been completely overlooked by the learned single judge, who simply says acquisition is valid and nothing more to be done. Now, the question was, acquisition was challenged in the earlier writ petition, challenge failed, but a further direction was issued. That
now let us see that.
Yes, ma'am, that's the point. Exactly. Fine, kindly see page 380. That's the direction on which, my lord, I'm placing my case before your lordships. The challenge to the, may I read it, my lord? The order portion of the challenge to the acquisition in all these writ petition fails and it is accordingly rejected. Acquisition proceedings are upheld subject to the following conditions. The relevant conditions so far as we are concerned, my lord, is at page 384. Capital B.
384.
384, my lord. all the petitioners who are landowners, converted site owners, duly converted for non-agricultural use of land in accordance with law, who are seeking dropping of acquisition proceedings insofar as their respective land sites are concerned, on the ground A, that their lands are situated within green belt area, that doesn't arise. B, they are totally built up, that doesn't arise. C, converted for non-agricultural use, that doesn't arise. D, my lord, is important. Garden and recognized nursery land, that is where we come. And I will show to your lordships afterwards what has happened. Are permitted to make appropriate application to the authorities seeking such exclusion and exemption and producing documents to substantiate their contention within 3 months from the date of this order. So, my lord, we were permitted to make appropriate application seeking exclusion and exemption. Accordingly, my lord, pursuant to this order that was passed by this honorable court on 6/6/2000, on 6/6/2006, we filed our representation on 15/7/2006. Your lordships may kindly turn to page 387. This is the representation that we made on 15/7/2006 to the commissioner of the BDA. I'm omitting, my lord, all the details. I will straight away take your lordships to, my lord, I'm given to understand, my lord, it is available in your lordship's record at volume number 2. May I trouble your lordships to kindly see page number 390, my lord, if your lordships are kind enough. With this, we quote, my lord, the order passed by this honorable court in the writ petition. With this, I submit to your good self that BDA had notified 101 acres, 39 guntas in Tudahalli village in its preliminary notification dated so and so. In the final notification dated so and so, BDA notified only 32 acres of 30 guntas, in which 10 acres, 35 guntas belongs to government. BDA has deleted 68 acres, 30 guntas of barren land, non-converted land and garden lands from acquisition. Survey numbers 48, 50, 51, 42, 22 and 23 are adjacent to our land and has been dropped from acquisition. This is the disparity and discrimination has happened to me. My garden lands in survey number 70 and 71 is totally developed garden having coconut, aracanut, valuable teak and other horticultural plants. These are only lands BDA has notified in the final notification. Now, this is the reason why the contention in the earlier writ petition was that similarly placed lands had been denotified and dropped from acquisition in the final notification. Our lands had been illegally discriminated against. Therefore, my lord, this direction was issued by the learned single judge in the earlier round of litigation, pursuant to which this representation was made. Give me the prayer and the presented petition.
So you are for
BDA.
Bangalore Development Authority.
I'm a peer for Bangalore Development Authority.
So, my lord,
You are for allotment.
and now what has happened, my lord, is BDA says during the pendency of the writ
They're
petition.
challenging acquisition.
Not pendency.
My lord, I am now saying, my lord, that there is a direction issued.
Before. This is actually forest land.
That is the different, my lord, that we will, in fact, we have succeeded before in respect of the forest land.
Pending in it. Order sheet. Writ appeal order sheet.
The units are constructed. No?
Beg your pardon?
It's an open land or units are there?
No, no, we didn't. It was sites which were formed. My lord, out of 10 acres of land, a substantial portion is actually forest land. And the forest department has taken over the forest land.
No, today this disputed land is open or constructed.
Right now, my lord, it is demarcated. Demarcated.
Open.
And sites are formed. I don't know if there are constructions. My learned friend will have to say because
Small sheds and other keeping the watchman to safeguard our properties.
We'll say status.
Really, my lord, today I can't say anything because so far as I'm concerned, I've allotted a small portion of the land. Balance of the land, my lord, is with the forest department.
That is a matter between me and the forest department. The litigation is pending, my lord, we'll take care of it. I don't think BDA is concerned with it.
No, BDA is concerned, sir, because
BDA,
I don't know.
BDA has passed a resolution saying that
Giving
we
it
are
up
now releasing this property from acquisition because it is forest land. So therefore, BDA is out of the picture.
No.
I showed you a lot of
It is
resolution of
because
BDA.
I'm sorry. It is because it is forest land, my lord. It was said it will be handed over to the forest department. That is different from saying I'm denotifying it for the benefit of the petitioner.
I'm not saying
My humble submission, there's a big difference between the two.
Consider my application. I know, my lord, it's not denotified. My learning is right there. But the fact of the matter is that insofar as the dispute in relation to forest land is concerned, it is a separate legal proceedings that pending. That's a different issue. I will fight it out. And that is confined only to 7 acres out of 10 acres. 3 acres, my lord, is still subject matter of BDA's acquisition.
I think my learned senior friend must explain also to your lordship as to how, during the pendency of these proceedings, he has executed an agreement and transferred practically all his rights in this property to someone else who also files a writ appeal and comes before my lord and doesn't disclose it to the court.
I will. If you give me,
he does not disclose all these facts.
If you give me an opportunity, I will definitely explain everything.
What happened to that matter?
Beg your pardon, lord?
What happened to that?
That writ appeal is connected in this proceeding. He claims a right independent of this and says I am entitled to challenge.
That is a totally different.
I don't know how
I can
transact with property of this
complete
kind.
answer to it. If I have transferred the property and I am entitled to relief in this writ appeal and in the representation that has been made, then my lord, let me complete, sir, if you don't mind. Then, my lord, by applying the doctrine of feeding the estoppel, feeding the grant by estoppel, he will become the owner. If he does not, if I fail, he gets nothing. So therefore, my lord, ultimately the acquisition is by me, from me.
So all through this process, someone can go on transacting with properties.
And this agreement was prior to acquisition, 2002.
Notification 2002. Our agreement. Document create ಮಾಡಿರ್ತಾರೆ. writ appeal ಕೊಟ್ಟಿಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
Well, hereafter.
For a moment, your lordship. For a moment, if your lordship kindly take to page number 390, which my senior counsel read out. Please, for a moment.
I was trying to read out.
390, may I continue that? Their contention was that as on the date of the earlier writ petition being disposed of, as it is a garden land, and they were to give a representation. They themselves in their application have stated, further I submit to your good self that BDA has dropped 390, madam, page number 390. For a moment, if your lordship reads, I'm able to read this to your lordship.
Having considered the subject matter
only this
involved in this appeal arising from the judgment and order of law in a single judge, having with the help of learned counsels appearing with parties, the appeal requires detailed hearing. It may be posted next on 25th of June. Full stop. Learned while learned senior advocate Mr. Raghavan would submitted that interim relief may be granted, otherwise the irreversible situation may obtain. From a learned senior advocate Mr. Yan Chinnappa for the Bangalore Development Authority, respondent 1 hearing two hearing stated that the parcel of land, which is subject matter of the appeal, subject to the proceedings, have been allotted to the
allottees not who are respondents here.
respondents, and that they are in possession of the respective sites. Full stop. When asked about the status of the land in the hands of the allottees, learned advocate Mr. Chandrachud stated that there is no construction put up. However, some temporary sheds are constructed. Full stop. In order that new equities are not created, and either of the parties to the proceedings is not prejudiced from a status quo as obtained today shall be maintained by all the parties.
Yes,
That not to be misread, that to be not misread anywhere else, ma'am. Because these questions of status quo will be misread in many matters, ma'am.
Therefore, what is the status? We already recorded.
Yes.
Great.
You are in possession,
Yes.
allotted, there is no construction, no litigation. This is the status. This is the status quo.
That is status. Yes, yeah, of course, that's great. Your lordship's been posted in June, my lord.
25th June.
Great.
25th.
Great.
Twenty-three point one was to what is to be done, notice returnable on the same date.
Very well, Lord, sir. In fact, they've all been served in that matter.
Yes.
24 is adjourned. Seal number 25. Mr. Ramurthy BV.
Delay is there, 44 days.
44 days.
So notice returnable on 26th of square. We'll condone the delay.
Please.
Leave application.
Yes.
Who are you?
I am a third party. There is a.
What is your relation?
There is a.
You are third party. We know that. What is your relationship with the subject matter?
It is the property of the forest land. It is allotted. It is a Gomal land, my lord. Now.
So you don't have any connection or nexus with the subject matter. You are in public interest.
It is in the interest of the.
You can file independent proceedings.
But they have suppressed the fact that the Gomal land cannot be allotted.
All grounds are to be visited in. Where is your application? Let us see.
This is application page number.
Judge by judgment and order dated 15th April 2024, passed in the writ petition. The whole petition. Dated, asked in writ petition number 10724 of 24. While disposing of the said petition number so and so so and so. While allowing the writ petition, following directions received. Paragraph 6, page 24, 6 to 6 and 7.
Well, the entire land was developed by the forest.
This will be order in, where is it?
IA 1 of 20.
IA 1 of 22. The present applicant who is a third party, applicants with the third party. 6 themselves to be 6 leave to appeal against the aforesaid judgment and order. The ground sought to be raised in support is that the land in question was a Gomala land and was reserved under section 71 of the Karnataka Land Revenue Act 1964. Said with Rule 108 of the grant rules. It is the case that land of such kind and nature cannot be granted to public. It was stated that the applicant had filed writ petition number 44573 of 1999 for this court for the grant of a portion of the land out of the said survey number 13 of 13 at Inana Halli village, Jagi Jena Halli Obli, Hoskote Taluk, which petition was allowed. However, the said facts have been suppressed by the petitioner who filed the writ petition for the national villages. On such grounds, petitioner prays for granting of leave to appeal. Full stop. The operative directions of law national villages in the impugned judgment, in the judgment and order which is sought to be appealed, which in respect of which leave to appeal is asked for, would necessarily shows that the proceedings are sent back by law national villages to Tahsildar to the committee.
When I have produced the documents.
After setting aside the committee requiring the committee to undertake the exercise is directed within stipulated time and take a fresh decision. Full stop. In the aforesaid view, the court does not see any good reason to permit to grant the applicant the leave to appeal. However, it is left open to the applicant, not petitioner, applicant to apply before the committee to submit his case, which may be considered by the committee in accordance with law and on merits, while undertaking a fresh exercise of taking decision as per the directions of law national villages. With such limited observations, the leave to appeal application is rejected. The application is rejected. Consequently, the appeal is also not entertained. Appeal also stand disposed of.
Much. Case number 26. Ajay Kumar M.
Please. The applicant is back. Bangalore Development Authority is an appeal before the Honorable Court. There is delay. We have filed application seeking for condonation of the delay, filing the said appeal as well.
Who are you?
We are the Bangalore Development Authority.
So delay with condon?
There are it is 292 days delays. We already filed a contempt petition. After that, they come before the court and file writ appeal.
So delay cost of 750. We paid to the High Court legally, so this is coming.
Please. Wait. Lord, state appeal, I have intimated the respondents. Kindly have it post vacation, my lords. I have intimated the respondents, my lords.
Which one?
My lord, I am appear for respondent number 3. My lord, in the appellant has not filed the objection filed to the affidavit in the learned single judge.
27.
26.
26, the appeal will go to.
No, 27, my lords. My
27.
apologies.
27.
Some documents has not been filed by the appellant.
You are mentioning 27, Mr. You are mentioning
27, ma'am.
27 is yet to come. Yet to come.
My apologies.
So 26 will go, appeals will be listed on 1st of July.
Lordship, some documents has not been filed. Some documents is not filed with the
File
appellant.
before the next date,
Direct them to file.
27.
July, 1st.
Number 27, state appeal.
I have intimated the respondents, my lords. Post vacation, it may be taken up, my lord.
2nd July,
Very much.
send out to 2nd July as requested. Learned additional government advocate, Mr. Chandrasekhar. And with no objection from the
My lordship is,
other side.
my lordship, appellants not produce the affidavit objection in the single judge order. Please let them, direct them produce the relevant documents, my lordship.
That is for the office. Yes. Or when we hear the. Yeah, next.
Number 28, Mr. Shetty Deepak.
The appellant plots is the Rajiv Gandhi University. The respondent is a pharmacy institution.
For respondent 2.
For respondent number 1, my lord.
In fact, lordships had heard this matter at the stage of preliminary hearing and granted an interim order. There is a question of law involved. There's conflict between the UGC regulations and the substantial provisions of the Rajiv Gandhi University. Law requires to be settled.
This can be, it's a good matter to be argued and also considered. But
Yes. But Rajiv Gandhi University of Health Sciences Act is a comprehensive legislation. It's a state enactment which completely.
your contention is that the university will prevail.
Yeah, this will prevail over the UGC regulations.
The judgments are otherwise.
No, but UGC regulations are subordinate legislations. In fact, their rule-making power does not contemplate this. We are the primary parent university which controls all institutions. Now they go and file an application and get an autonomous status, which practically nullifies the institution. That is the question of law. Of course, no learned single judge has.
Interim leave is granted.
Sorry.
Interim
Order is granted by lordships. In fact, lordships heard the matter for some time and then granted it.
19th of June.
Please.
My lord, the interim stay would affect the respondent number 1 because the in April 25th, the examinations are coming on.
And to 19th of June, the interim order granted earlier shall continue over till further order.
Please.
My lord, if a date can be fixed for the next.
It is already fixed, 19th June.
Still number 29. Mohammad Ashar.
Here for appellant's counsel, my lord. Connected case in writ appeal number 1529/24. Notice has been issued, is posted to 19/6, my lord.
19/6.
Number 30, Mr. Narayan Bhatt.
What is this group? TDS?
For the appellant. Matter may be taken up after vacation.
May make one comment. My lord, all the 47 matters are identical matters. Yes. It is under payment of gratuity act. My lord, after 5 years, my lord, they have filed a application.
TDS.
TDS. There is no stay. There is no stay.
TDS.
Only one submission, my lord. Whether the controlling authority under payment of gratuity act has got power to interfere in tax deduction out of gratuity amount paid by TDS. TDS was remitted to income tax department about 10 years ago. Form 16 was given. We are not aware whether they are claimed refund or not. Their main grievance after 5 years of taking the gratuity was that they were yet to get additional amount of gratuity. They have filed application. Controlling authority said gratuity paid is in order. But the tax deducted under TDS is not correct. I have been directed to refund the tax. Tax has already been remitted. It is not whatever that is permissible under Payment of Gratuity Act. I have not deducted any tax. Over and above that, I have a private scheme.
Maybe taken up next week, minutes.
I have a private scheme. On that amount, tax was deducted. It is totally without jurisdiction. He is the determining authority under Payment of Gratuity Act. This is the only issue involved in all the cases, madam. Madam, all the 47 cases, this is the factual position. I may after vacation.
Interim order is
No, interim order is not there.
in some cases there is.
No, I oppose interim order. This is the, if interim order is granted, it is as good as allowing the writ petition.
I am not asking you, wherever interim order is there, let it be.
Interim order is granted.
Only in ex parte interim order in first writ petition.
So it operated now.
That's all.
Only in first writ appeal. Your lordship on the last occasion, after hearing the matter, as directed as extended interim stay only in first writ appeal.
All are identical.
Identical, same matter.
Only in other cases, IA is there. It has to be heard. Only in first writ appeal. That is ex parte order.
3rd of July. Interim order shall continue to operate.
In first writ appeal, my lord.
All are identical.
No, my lord. The other matters, it has to be heard. It was past expired.
Why should we heard?
It would.
My lord, then, my lord, it is executable order. I am required to refund the tax amount.
They will go and file a refund order. They will file for refund.
Refund TDS amount, which has already been remitted to Income Tax Department. That is the problem.
By virtue of interim review.
Yes, yes.
Please.
My lord, I have remitted TDS.
Wherever it is granted, it will continue.
Only in the.
Only in first writ appeal.
Only in first. Only in first.
Granted earlier shall continue.
Yes.
Whichever don't right.
Seal number 31, state appeal.
Lord, there's a delay of 367 days. My para 8 of the affidavit, I have explained the delay, Lord. Elaborate delay.
How many days?
367 days. More than a year, my lord, since the order of the learned single judge. This is a
delay is gone down with cost of rupees 2,000.
Sorry.
We paid to the.
This is, my lord, a classic case of decades of delay. Continued repeatedly. That's the only reason we filed our objection. Otherwise, I wouldn't have opposed it.
Delay is gone. The state is always entitled to. State always works in.
But of course, in this case, in one case, 14 years delay. In another case, of course, by that standard, not they are early.
When shall we take up the after vacation?
Next week of June. Next week also I am ready, my lord, or soon after vacation, my lord, may I request?
9th of April, 9th of June.
9th of June. Grateful.
Seal number 32, sumoto writ petition.
May please, my lordship. Actually, we have sought for the early hearing because the Supreme Court, Honorable Supreme Court has requested the Honorable High Court of Karnataka to dispose it at the earliest stage. It has been 1 year, my lordship. The matter is related to the temple and the trust, my lords.
This can wait after vacation.
My lordship?
4th of July. Supreme Court.
So, Supreme Court order he is quoting.
Yes, my lordship, it is related to a trust, but the trust was not implemented as a party, my lordship. Just out of a political and a personal vendetta, they have just raised the claim. And even in the land grabbing court also, it has been granted in our favor. And also,
For the petition.
my lordship,
Who is for the petition?
my lordship, petitioner, no one has appeared. We have just served the copy also.
Petitioner is not present.
And they told the Suyomoto has been.
13%.
Mm.
13%. Who is appearing?
Kalyan Baswaraj Malad.
Yes, my lordship. My lordship, we served the copy, but he told we are not anymore appearing for the petitioner because this is a Suyomoto.
So keep it on 28th.
28th of April, my lordship.
None present for the petitioner, or in view of the order asked by the Honorable Supreme Court dated 12/3/24 in special leave to appeal C, regular number 5649 of 2023. Petition shall be next listed on 29th.
29th, my lordship.
29th of.
Can we have it on 30th, my lordship? 30th, if any possibility.
30th, nobody will come except you and me.
Oh, sorry, my lords. Much obliged.
My lord, can I take notice for respondents 1, 2, 3 and 4, my lord?
Yes, 30.
Number 33. Master RKGMM Mass one.
Respond.
My lord, immediately after I got the relief on administrative side, the appeal will be withdrawn, my lord. Short date in this month, last week, my lord. It is short date in this month, last week, my lord.
Short date.
Yes, my lord.
Tell you.
Immediately after I got the relief on administrative side, the appeal will be withdrawn. Please, my lord.
This will be withdrawn.
Immediately after I got the relief on administrative side, appeal will be withdrawn.
We do not. Whatever you want time, then you will.
Yes, sir. Yes, my lord. This month. This month, last week.
Learned petitioner part in person 6 times. Stand over to.
This month, last week. This month, last week, my lord.
This month not. This month there is no time.
Please, my lord.
It will go to 19th of June. 19th June. As requested.
Seal number 34.
As requested. 19th of June as requested.
Appellant. My lord, with respect to certain allotment that had been made by Muda in favor of respondent number 9, who is the wife, my lord, of respondent number 1, who is the Chief Minister of the state. An application had been made, my lord, under section 17 capital A of the Prevention of Corruption Act. The Honorable Governor, my lord, granted permission under section 17 capital A for the investigation.
The order sheet shows the stand over to 29 for.
My lord?
The order shows that it was kept on 29 for.
I am told, my lord, it was mentioned for your lordships for a.
Then he never knew that it is already adjourned. Now today we are told.
Your lordships can issue notice, my lord. All that we'll do is today, all that I can ask for your lordships is to issue notice to everybody, all that. And I must also point out, your lordships, my lord, that the sanction or the approval accorded by the Honorable Governor to hold investigation, my lord, against the present Chief Minister for misuse of the office in relation to allotment of sites by Muda in favor of his wife. That order passed by the Honorable Governor was subject matter of challenge by the Chief Minister, my lord, before this Honorable Court. That challenge failed. As against that challenge, a writ appeal has been filed before your lordships, and your lordships have now posted the writ appeal, my lord, on 28th. So may I request, my lord, that this notice may be issued to all the respondents and the matter may be posted on 28th.
So I write down IN number 2 of 25 for early hearing doesn't survive, as the writ appeal number 333. Writ appeal itself is posted today for admission hearing.
Yes.
Full stop. Heard learned senior K.G. Raghavan for the petitioner
Appellant.
For the appellant. The appeal is directed against judgment in order dated 7th February 25 of learned single judge, whereby learned single judge has dismissed the petition.
Declined to refer the matter for investigation to the CBI.
Declining the prayer of the original petitioner to refer the subject matter for reinvestigation. For reinvestigation.
No, for investigation itself.
For investigation by the Central Bureau of Investigation.
Yes.
By the Central Bureau of Investigation. On a single judge, while declining while not acceding to the request, recorded certain summary of findings which are raised in that, then page 151, 1, 2, 3.
Earlier, my lord.
In the facts of the case, heard learned senior advocate Mr. K.G. Raghavan, assisted by learned advocate so and so. Your name? Give the appearance. You are not appearing.
First respondent, Lord.
Formally appearing or not appearing?
No, I'm appearing. I'm to appear. As of now, my lord, looks like we are formal parties, but my lord, I am representing the union.
We'll say learned advocate must come. He's just sitting and not.
My learned friend, my lord, is in an awkward position. This matter. You can't say I will take notice and appear. You can't say I won't.
No, we have received copy of the report.
Learned Arts and learned Additional Solicitor General, Karnataka, Mr. Kamath, who is present in the court, submitted to the court that the copy of the appeal may be furnished to them, as they are likely to appear on behalf of Union of India. No.
First respondent union.
First respondent Union of India.
First respondent. Full stop. Learned advocate.
CBI.
Full stop. Paragraph. In the facts of the case, there shall be notice. In the facts of the case, there shall be notice to the respondents returnable on after vacation.
But the other writ, as I indicated to your lordship's my lord, sanction had been accorded by the Honorable Governor for investigation. That writ appeal, that was challenged before the learned single judge, and that challenge failed. As against which, my lord, the respondents here have filed, the contesting respondents here have filed writ appeals which are coming up on 28th. So I, in your lordship's hands, my lord, whether this matter can also be posted on 28th, and then I leave it to your lordship's my lord.
Yesterday the matter.
Beer button bedding sundari bada. No. ಎಲ್ಲ ನೋಡಿ ಬೀಗ ಬೇಡ ಅದು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಬೇಕಾಗುತ್ತೆ.
Let it go up. It will be, hearing will not be over.
I know, my lord. Because those matters are posted on 28, I was only seeking your lordship's indulgence to see if this can be posted on that day. On that day, whatever your lordship decides will happen, my lord. That is a different issue. I understand, my lord. That is the last but one working day, and a matter of this kind, I know, my lord, will not be taken up because we will have so many urgent matters before your lordships. I understand, my lord. But because all these matters are connected, it can be brought together is the only submission I'm making. I'm in your lordship's hands. Because the substantial question as to whether investigation at all can go on is subject matter of that writ appeal. No, this is the one. Those writ appeals, my lord, I'm sorry.
When the relief in a petition, relief in the petition, which is otherwise under Article 227, travels beyond what is prayed for, or certain additional observations are made, touching upon the rights of the parties, then could it be said that it is under 226?
My lord,
Those directions are by exercise of powers of the court under 226.
yes.
Though the original, that is the ultimate law.
That's ultimate. It will be 226 and read with 227.
No.
226 actually.
Really mentioning it, you have to demonstrate.
Yes, my lord. If your lordship sees this order, it is purely under 226. Because the direction that we sought, my lord, before the learned single judge was, the matter should be referred to the Central Bureau of Investigation and not be left in the hands of the investigation wing of the Lokayukta, because according to us, the investigation wing of the Lokayukta is subject to the overall superintendence of the government, which is headed by the person against whom the accusation is made, namely the Chief Minister of the state. And on this, my lord,
These questions might arise.
in fact, on this question, I anticipated, my lord, the question from the bench. And on this very question, there is a judgment of this honorable court, my lord, a division bench judgment of this honorable court, where this honorable court was going into the question as to whether, in a situation of this kind, whether a writ appeal would be maintainable or it should be a SLP to the honorable Supreme Court.
So ultimately, what are the yardstick to judge?
Yardsticks would really be, my lord, first, this is not a case where I am challenging an order passed by a court. Therefore, my lord, this is not an order coming. I am asking for a mandamus.
There is an independent prayer in the petition to refer the investigation to CBI.
Yes, that was the main prayer.
Independent.
The relief in the writ petition was
independent or in the context of.
No, my lord, it was an independent prayer made in the writ petition, and in fact the only prayer. Please refer this matter for investigation to the CBI, because the investigation wing of the Lokayukta is subordinate to the government. Where is the prayer in the writ petition? Prayer in the writ petition. Give me the prayer. My lord, the prayer in the writ petition. 194. In fact, if your lordship will kindly see the prayer in the writ petition.
What did you write?
I'm sorry.
Yes, we'll see.
Where?
There shall be note in the respondents returnable on 29, since it was stated.
28.
28.
28. Of course, my lord, I know, my lord, it's the last but one working day.
Since it was stated that appeals connected to the subject matter controversy are slated to be listed on that day.
Yes, and notice to all, your lordships may permit me to take out hand summons, my lord. I will serve everybody, and so that on 28th, we will ensure, my lord, that the service aspect of the matter is complete. Then I'm in your lordship's hands as to when the matter will be heard, my lord. That's
This might require independent hearing. Why do you connect?
the reason is this, my lord. If
the connecting will confuse you.
No, my lord, I tell you, lordship, why
in the sense that when the questions of law are to be addressed, not in other sense.
There is only one reason why, my lord, I'm saying that.
And more particular maintainability.
My lord, I understand. That's a different. My lord, I tell you, lordship, why I'm saying it could be posted on 20th. My lord, in that writ appeal, the question is as to whether the approval accorded by the Honorable Governor for investigation under 17 capital A of the Prevention of Corruption Act is right or wrong. Learned single judge, my lord, said that Governor was right, that there was enough material to show that this required investigation, as against which a writ appeal has been filed. If the writ appeal is allowed, and this honorable court comes to the conclusion that the order passed by the learned governor is wrong, then the question of referring it to CBI for investigation will not arise, because the investigation itself collapses. That is the reason why, my lord, I thought I should.
So you are not appearing in those matters.
I am.
You are appearing.
Yes. In all those matters, I am appearing.
Service.
Hand summons will take out to everybody.
By hand delivery is permitted.
Yes.
We'll see. Maintainability is not to be judged by the office. It is we who will judge. It is annoying that the office is judging about maintainability, not in this matter.
Of course, my lord. Actually,
we feel that our jurisdiction is taken.
Exactly. And in fact, my lord, the Honorable Supreme Court has now taken the view that every writ petition is maintainable. Whether it is entertainable is a different issue.
Here, the maintainability is part of office objects.
Can't be, my lord.
It is not comprehensible for at least for me.
Of course, my lord. Entertainability is in your lordship's hands.
Even maintainability.
Maintainability is in your lordship's hands. Of course, my lord. And actually, my lord, as I understand the legal position today, there are two recent judgments of the Honorable Supreme Court, my lord.
Entertainability is often in the hands of lawyers also. If they argue well, then we entertain. So this is all in lighter way.
I know, my lord. Actually, my lord, this distinction has been made by the Honorable Supreme Court, and the Supreme Court has said every writ petition is maintainable. Whether it will be entertained or not is a different issue. I can come before your lordships against an order passed by a Tahsildar, over bypassing every other remedy available under the statute. Whether your lordships will entertain it or not is the prerogative of the Honorable Court. Great.
This is number 35, Mr. Satish K.
Counsel for complainant, my lords. May I request your lordships to have this matter next week, my lords? Senior counsel has some inconvenience.
Lord, I have filed a compliance affidavit on 19/8/2024. There was a direction, my lord, to consider his representation for appointment by transfer. Lord, I have done that and filed an affidavit, produced the order also, my lord. If he is aggrieved by this order, my lord, he has to challenge. His grievance is, my lord, that he has to be appointed from a prior date. He has taken birth, my lord, in that particular cadre on a particular day, my lord, and I have given it effect to it from that particular day when he took birth in that cadre, which is 5/5/2018. He's been appointed from that day, and my lord, he is also given seniority based on that date, which is reckoned, my lord, in my affidavit. Kindly see my affidavit of compliance, my lord. Initially, I had rejected it.
Any date next week, my lord, as per your lordship convenience.
2:30, any urgency, then after vacation. Go to 2nd July. Since it was stated by learned advocate for the This is a contempt petition.
Contempt not. Annexure A is the direction to consider. But I had not given him appointment on the basis that Lokayukta inquiry was pending.
Where is that direction page?
Page, my lord,
21.
2021, lord.
Endorsement dated is cost, matter is remitted to corporation to take decision in light of the observation made in.
Yes. Page 19, lord, paragraph 5 is extracted. I have filed compliance affidavit on 19/8/2024.
So what is this writ petition 5097, annexure M? You have complied with according
Yes,
to.
my lord, I have complied with the order. Now his grievance only is that you have appointed me, but you should have appointed me from some retrospective date.
That it was considered earlier.
Yes, my lord.
I filed the rejoined affidavit minutes on 22/8/24 as per my
Kindly
instruction
see
minutes, it
annexure
is not-
R1, my lord, page 6 of my
As
affidavit.
per
There
my
is a detailed
instruction
order.
minutes, it has not been compliant. Senior counsel is engaged minutes. Any date next week minutes. Your lordships.
Light of. See a positive A direct. Light. When shall we keep?
Lord, any time, Lord. Lord, I fully complied with the directions. That nothing survives, my lord. If he is aggrieved by this, he should.
As a last chance minutes, senior counsel is engaged. Any date of your lordships.
8 times they have taken adjournment.
Date then 11th June.
Great.
Number 36, Virupaksha PH.
But the direction of the Honorable Single Judge Malot is at page 26, my lord. The respond number 1, my lord, was directed to continue the petitioners, my lord. The last 2 lines may I read, my lord. Directed to continue the petitioners on daily wage basis as scavengers till regular recruitment is made, and also to provide petitioners opportunity to participate in the regular recruitment process.
The compliance affidavit, we have given the letter to them to do the same, my lords.
Lords,
Now also they are free to come and report for the duty.
if your lordship may kindly peruse, my lord, annexure R1, which they have produced, my lord, at page 8, my lord. The direction was to, my lords, take back the petitioners on duty, my lords, in the first respond office. Now, if your lordship kindly peruse page 8, my lord. This letter is issued, my lord, after 2 years, my lords, from the date of order of the Honorable Single Judge. My lords, may I read, my lord, page 8, my lord.
What you are doing?
My lords, we requested, my lord, to take us on duty. My lords, may I read?
They are ready to comply.
We are ready, my lords.
My lords, they say, my lords, only one para, I'll read, my lord. Para 8, page 8, my lord. My lords, as per the order dated so and so 7/7/2017 of the Finance Department, the appointment of part-time, unskilled, non-expert workers has been restricted. Therefore, the action has been taken to appoint you to this office from the agency providing human resources to this office. My lord, now they direct me to report for duty, my lords, through the outsourcing agency, my lord. In fact, my lord, this honorable court had directed the department itself, my lord, to take me back on duty, my lord. For the past 2 years, my lord, they have not taken me on duty. No salary is also paid, my lords. They are working as sweepers, scavengers in the first respond department, my lord. In fact, writ appeal was also filed, my lord. Annexure C is the order by the department, which was dismissed, my lord.
Which is the department?
My lord, it is Hindu Religious Institution and Charitable Endowment Department.
So you take back.
Then we will, I'll advise them to correct the.
Then they are saying that agency. The agency. You are willing to go or not?
My lords, we are ready, my lords, to work, my lords, in the first respondent office, my lord. Now they direct me, my lords, to come back on through the outsourcing agency, my lord. And my lords, I was previously appointed, my lords, by the department.
You're daily wager.
I am a daily wager, my
Now
lord.
you are getting probably a kind of better status. And we will say that you will be continued.
Lords,
under the same
There's an
arrangement
entitlement,
till the regular recruitment is undertaken, where you will be having right to
I
participate.
may be permitted to work, my lords, in the wherever I was working previously. Now, my lords, by the letter which they have addressed through the outsourcing agency, my lord, if I am displaced, my lords, to any other place, my lord, the agency will be, my lords, directing me to work, my lords, any other office.
It is the continued petitions on daily wages as scavengers. Still regular appointment is
Please, my
made.
first respond department, my lords, I am ready, my lords, to. My lord, only due to their lapses, my lords, for the past 3 years, my lord, I have not been able to join for duties.
Did you take instructions?
I'll get the same.
Don't you put them
The anomaly with regard to the outsourcing agency, I'll clarify and I'll get the
My
instructions.
lords, next week, your lordships may, anytime.
28th, my lords.
29th.
Very much.
I'm grateful.
29th at 2:30. They are without job, you do it.
Please.
At the same time, they are not coming, but then.
I'll
My lords, soon after the order of the Honorable Single Judge, my lords, we have addressed representation and made a request.
The order is passed when?
2022, my lords, December.
29th will address the issue, my lords.
So that they get job at least.
Very much, my lord.
Please.
Very much.
Great.
37 disposed. Seal number 38, Mr. Rajeshwar PN.
Let's I appear for the petitioner in this case, minutes. The direction of the Honorable Division Bench of this Honorable Court is at page number 16, minutes. BDA has to allot me a land in lieu of the compensation for acquisition of the petitioner's land, minutes. The order is of the year 2019, minutes, which has not been complied with. Minutes. Not been allotted the land, minutes. Acquisition.
We'll file our compliance affidavit, minutes. Kindly 2 weeks time may be granted.
While allowing the appeal, following directions are issued by the division bench in paragraph 5, page 16, 5. It is the aforesaid directions contained in judgment and order dated 21st October 2019 passed by the division bench, which are brought under consideration. In addition, that this is barred by time.
There is a delay of 730 days, my lords.
My lords, there is no time frame fixed in.
Delays?
730.
Yeah, it is mentioned in the.
My lords, there is no time frame fixed in the order of the Honorable Division Bench, my lords.
That is worst. There are two reasons. 38. There are two reasons why the contempt petition would not be entertained by the court. Firstly, the directions does not prescribe a time limit for compliance. It was for the petitioner to put the respondents to notice about the time limit within which asking them to comply with the direction within such time limit. Secondly, the order of learning single judge is dated 21st October 2019. The contempt petition is filed on 7/27 to 24. Evidently, it is after passage of 1 year. Paragraph. Section 20 of the Contempt of Courts Act 1971 reads as under in court section. Full stop. Therefore, it was incumbent on part of the petitioner to file the contempt petition within 1 year from the date of arisal of cause of action to initiate the contempt proceedings. Full stop. The contempt petition filed days ago is manifestly barred by virtue of provision of section 20 of the Act. The present petition is therefore dismissed.
My lords, if I may submit, my lords, the acquisition is of the year 2004. my lords.
Heard learned advocate Miss Rajeshwari.
Aishwarya.
Video conferencing and learned advocate Mr.
Ajay Kumar.
Ajay Kumar for the respondent.
Lords, may I request that the time frame be fixed by my lords. My lords, the order is of the year 2019. My lords, they have not complied with the order. My lords.
This order will not.
My land is acquired in the year 2004, my lords. They have not given me the compensation, my lords, in the alternative site, my lords.
This order will not preclude the petitioner to avail the appropriate recourse in accordance with law to enforce the direction. In respect of it, this court, however, does not express any opinion on merits. Next.
Number 39, Mr. Satish Gael.
Lord, I have complied with the direction, my lord. It was in fact a direction of the Honorable Supreme Court, my lord. There was revision of pay, totally 12%, my lord, 10 plus 2. 2% was based on performance. I had to do evaluation, my lord, for the 2%. I have
14 were left out.
Yes, my lord, 14 were left out, my lord. There was a direction that I should issue an endorsement. I have done that, my lord, and filed an affidavit on 25/9/2024.
Short accommodation, my lords. We have engaged senior
Nothing
counsel.
survives. Nothing survives because I have complied with the order.
Kindly have it on 21st, my lords. Apologies, my lords.
21st.
Please, my lords.
21st at 2:30. Please, the request of learned advocate for the petitioner, whereas it was stated by learned senior advocate so and so that in any of the affidavit lastly filed, the contempt petition would not survive. Come, please. If it is not surviving, they withdraw, other will be passed appropriate order.
Please.
Next.
This is number 40, Mr. H.C. Shura.
None is present. Stand over to 8th of July. You are there?
41.
You are there in 40? 40? Next.
Number 41, Mr. Vedamurthy MV.
Yes, I am for the petitioner, Your Honor. This honorable court has pleased to pass an order on 7/12/23, Your Honor, by quashing the charge and directed the same petitioner is entitled to all consequential benefit that would arise, and the same shall be paid within 2 months from the date of receipt of this order. I served
A3 is the answering respondent.
order
A3.
copy on 28/12.
A3 is the answering respondent, my lord.
Food and civil supply.
Very much. MD of Food and Civil Supplies.
Whoever.
One Mr. Muralidhar, my lords.
Since 1.5 years, Your Honor. (28/12/23), Your Honor. Page number 19.
Learned single judge has held the petitioner to be entitled to all consequential benefits which would arise to be paid within 2 months. Full stop. This is upon charge sheet and the inquiry report against the petitioner. This is upon the setting aside of the charge sheet and inquiry report by the petitioner, by learned single judge, allowing the petition. Full stop. It was stated in course of the hearing of the contempt petition by learned advocate Mr. So and so that respondent 3 managing director Karnataka Food and Civil Supplies is the authority who would comply with the directions to pay the benefits as directed by learned single judge. None is present for the respondent 3. Learned additional government advocate Karnataka Mr. Chandrasekhar is present on behalf of the 1 and 2. Full stop. Since it was rightly submitted since 1.5 years, The petitioner stands deprived of the benefits despite the clear direction of learned single judge, nor it is given out that direction per paragraph. There shall be notice again to respond 3 in absence of learned advocate appearing for number 3, respond 3, returnable on 12th of June, before which date, comma, the compliance on which date, on or before which date, the compliance of the directions of learned single judge about payment of benefits, consequential benefits to the petitioner shall be acted upon, and the details shall be produced before the court on the next date on affidavit, failing which the court will be compelled to pass a stricter order. Service by end delivery is permitted. You serve them.
I served the copy.
Again, press notice.
Press notice.
Yes.
Number 42.
We have complied.
Ranganath.
42, 43, both are similar.
Keep back. Second half.
Very much.
Number 44. Mr. Veerabhadra MC.
Complied, my lord.
Veerabhadraya.
Complied, my lord. You also filed memo along with allotment
44 is
letter.
complied.
Complied, my lord.
Who appears?
Copy also served to the
Keep
other
back.
side.
Nobody appears. Second half.
Number 45, Mr. R.J. Agde.
Complainant in this matter. But the last occasion, they filed a memo stating that the complainant certificate has been cancelled by the Deputy Commissioner exercising the power under Section 4F of the Act. Now, that is not the answer. This is going on since 2019. They were given liberty in the year 2019 to take action under
The order is passed. What is happening?
My lords,
Order
what
is-
happened is,
order
my
is
lords,
to-
caste certificate should be given by the Tahsildar, my lords. So caste certificate in favor of the complainants was given by the Tahsildar. Tahsildar realizes that it is based on false information. So he cancels the caste certificate, which is not permissible under law, my lords. So the court holds upon their writ petitions, 2 consecutive writ petitions, that Tahsildars, once he becomes the issuer of caste certificate, becomes a functus officio, and he can't cancel the same. But the court in the same light also says under 4F of the Act, the Tahsildar can make a representation or prefer an appeal before the Deputy Commissioner. Till such time, the caste certificate survives, my lords. So they are entitled for the viewing of the caste certificate and downloading of the same in the government website. But now, upon the application made by the Tahsildar before the appropriate authority, that is the DC, the caste certificate has been cancelled upon notice to them, my lords. Now they have to challenge that order as such, my lords.
The contempt, alleged contempt is this. An order is passed by the learned single judge
You have
on
not filed it.
29th February 2024.
File reply.
My lords,
You file your reply.
I have filed the memo along with the order passed, my lords. I have also served, my lords.
Where is that memo?
Memo was filed on
But may I make
2nd April 2025 along with the translated copy.
1st April.
2nd of April 2025, my lords.
my submission is this.
Yes. Order dated 21/3/25.
Very much, my lords.
My submission is this. This order, the matter under consideration is 29th February 2024. The order is passed by the learned single judge, directing them to upload the caste certificate so that they have the accessibility to the official portal. Now kindly look at the order now passed by them. It is in the year 2025 when the contempt petition is filed. There was a direction by the learned single judge that will have to be done forthwith. They never did it. Now thereafterwards, I filed this contempt on 20th of September 2024. They did not do it. Notices were issued to them. they come before this honorable court. They never file any statement of objection or compliance report. They, in fact, this honorable court but they cannot sit in appeal over the 11th single judge's order for so many days and say that we are not answerable. We have our own course of action. We will be, and I doubt very much whether they have the locus standi to approach the deputy commissioner to cancel our certificate. The liberty given is any person aggrieved, whether the Tahsildar or the assistant commissioner are the aggrieved persons, because they are the party, they are the authorities, they initially pass the orders. Now they cannot move the deputy commissioner to circumvent the order of the learned single judge to annul the order of certificate which is granted in 2019. Time and again, the learned single judge has stated that if the remedy is available, the first of its kind in 2019, they were given the liberty. Thereafterwards, contempt was filed. But I will give certain dates. On 23/4/19, this honorable court passed the order. That has been called out in the order of the learned single judge. Thereafterwards, the 2019, the first order is passed, stating that Tahsildar cannot cancel the caste certificate, he becomes functus officio. In the very same order, a liberty was given in 2019 itself. They kept quiet. Again, I filed writ petition in 2022. That was also allowed. Again, writ petition was filed in 23. Now, writ petitions after writ petitions were filed, they don't take any action either to obey the orders of this honorable court, and when the contempt notice is issued, all of a sudden they will approach with the deputy commissioner.
Order is passed under section 4F.
My lords, page,
Four.
very much, my lords, 4F of the said act, my lords. Because liberty was received, even including the respondent number 1, page.
Heard learned advocate, there is nothing now. There is there is no caste certificate
As on today, my lord.
Fake caste certificate, my lord, it is not as if I have taken the caste certificate and kept itself. No, I have not made use of this caste certificate. It was the subject matter of the so many writ petitions. They have made us to come to this honorable court many number of times. But if at all I have done anything, they could have immediately taken action in 2019 itself. They could have cancelled it. Why have they not done it? Even after passing of the learned single judge order, they did not take any action. Now only when the contempt petition is filed, they come forward. Not is it the compliance? They never say before this honorable court.
There is no compliance. You lost by virtue of subsequent development.
But for the period from the date of passing of the learned single judge's order till this contempt petition notice is issued.
Learned advocate, Mr. For the petitioner and learned additional government advocate, Mr. Naveen Chandra,
very much.
the respondent state and its authorities. It is the following directions contained in judgment and order of learned single judge dated 29 February 24. While allowing the writ petition, are made subject matter of non-compliance and in turn brought under the jurisdiction of the court under the Contempt of Courts Act 1971. Fourth paragraph 5. Whereby learned single judge directed respondent 4 and 5 to upload the caste certificate on the web portal and make the caste certificate accessible to the petitioner forthwith. Is these directions, Karina, which are contempt matter of, which is contempt, it's subject matter of contempt petition. Full stop. While the orders were passed in the proceedings time to time, today when the petition comes up for consideration, learned additional government advocate invites attention of the court to the memo dated 241/2 1425 filed by him, along with which order dated 21/3/25 passed by the deputy commissioner, along with its English translation, is produced. The said order of the deputy commissioner is passed in the proceedings of division number 128/24, 2024-25, where the petitioner was assistant commissioner and tehsildar. By the said order, by virtue of the said by virtue of the provision of section 4, capital F of the Karnataka scheduled caste, scheduled tribe, and other backward classes into reservation of appointments, it is, etc., full stop, bracket, or Act 1990, the deputy commissioner enjoys the power to either upon application or suo motu to call for and examine the records relating to any decision made or order passed by the tehsildar under section 4 capital A of the 4 capital A or under section 4B by the assistant commissioner for the purpose of satisfying legality of the order. Full stop. So the order dated 21/3/25 passed in the revision proceedings, the caste certificate in question has been cancelled. Full stop. In view of the above paragraph, subsequent cancelled by the deputy commissioner. Paragraph. In view of the subsequent development, the question of acting upon the directions of learned single judge to upload the caste certificate does not arise, inasmuch as, at present there is no caste certificate in existence in eye of law, or even in fact. Full stop. Either is not in existence, in fact, and in law. Full stop. In the circumstances, the court is not inclined to entertain the contempt petition, not inclined to exercise the, in the circumstances, the powers under the Contempt of Courts Act are not required to be exercised. Full stop. Learned advocate for the petitioner's right to submit in vain that the order was passed at the subsequent point of time by the deputy commissioner, and in the meantime there was a duty cast on the respondents to upload the caste certificate. Full stop. This submission has no legs to stand, inasmuch as, full stop, when at present the caste certificate does not exist and stands annulled and cancelled, the contempt does not arise in any respect. The petition is dismissed as not surviving.
But we may be given liberty to challenge that order.
Which order?
4F order.
It is always full stop. It goes without saying that the petition shall have liberty to challenge the endorsement dated, order dated 21/3/25 passed by the deputy commissioner in the revision proceedings in accordance with law, in respect to which, however, this court does not express any opinion on merits. 45 is over.
46. Mr. Abhishek Invi.
There's a direction issued by the single judge to settle my pension and other retirement benefits within a period of 2 months.
I appear for the respondent number 3, my lords. We have the BESCOM has challenged the order of the learned single judge, my lords, in writ appeal number 1577 of 2025. I just 1577 of 2025, my lords. Your lordship may.
So stated by learned advocate Miss so and so that writ appeal number 1577 of 25 is filed against the order brought under the contempt. In that view, these contempt petitions will be listed along with the said writ appeal.
Grateful.
What is the status of the appeal?
My lord, it has to be listed before this honorable
Full
court.
stop. As far as it is directed that the appellant in the writ appeal shall remove the offer of objections within 4 weeks from today.
Grateful.
Whereafter the registry shall immediately list the contempt petition as well as the writ appeal before the appropriate court for admission hearing.
May I request for a date, my lord?
Once they remove, all right, one date, shall list the so and so on 19th of June.
Of that.
Grateful.
Number 47, Shrimati Lakshmi Menon.
Yeah. RFA appeal is filed, my lord. RFA number 1877 of 24. Appeal is filed against the order passed in OS, my lord. RFA 1877.
What is the status of appeal?
Emergent notice issued.
It was stated that appeal number, writ appeal number
1877 RFA, my lord.
1877 77
of 24.
Same number I have.
This RFA, my lord.
Here you are there. No. We'll keep it back. Keep back.
In synopsis, they mentioned, my lord. In synopsis, they mentioned appeal is pending. Please.
Let them come.
Please.
Number 48, Ashok T.
Lord, I'm appearing for the complaint. We have not been served with the statement of objection, my lord. We have not been served with the statement of objection, my lord.
My lord, this apart from objection, my lord, this contempt petition is liable to be dismissed with exemplary cast. The facts are this, my lord, in respect of a MD seat, the complainant was earlier selected by the Karnataka Examination Authority. That was cancelled for due to some technical reasons. Thereafter, seat is given to me, respondent number 5. And I've continued in studies for nearly 2.5 years. He challenged my seat allotment, and ultimately his writ petition was allowed with the direction to give him his seat. Seat was given to him, and therefore thereby the order has been implemented. And now he filed a fresh writ petition. Since 2.5 years I've studied, there was another vacant seat was allotted to me.
Where are the directions?
Direction is only to give a seat.
My lord, can I request my lord to turn to page number 42, my lord, for a second.
Where are the directions?
Page 44, my lord.
There is no direction 44. Come after it. If you're not ready, no, don't waste the time.
No.
To be listed on. No, mister. Where is the direction to be complied with? Show us this contempt matter, this touch and go.
My lord, I'm coming to that, my lord. Page number 42, my lord.
42, there is no direction.
No, that is a, it is observed by the learned double bench.
We want direction. We want direction, not observation.
Operative
if you're able to point out, then point out, otherwise after.
Page number 58, my lord. Only
not your duty, it is duty of the petitioner.
My lord, what happened, my lord? Now he has,
to 9th of
my lord,
July.
1 second, my lord. Now he has
No,
filed,
nothing doing. It is gone. Yes.
my lord, now he filed a case before Lokayukta.
We are not here to waste the time in useless debates. We don't want time to be wasted in useless debates. We have lot of matter to be dealt with.
I've been harassed.
Yes.
49, PAL.
If you are ready, then come. Otherwise, not. Yes, next.
Sharon Desai, party in person.
Which one? 49. PIL.
The Lordship had passed
It
detailed
is
order
related to
on-
Gulbarga, Kalburgi Fort, my lord.
Oh.
Seek permission.
So affidavits are filed?
Yeah.
Affidavits are filed by?
Yes, my lord. Yes, my lords, we have filed affidavits.
My lord,
on-
I have served my copies of the affidavit on both the parties. my lord. I may be permitted to file. I may be permitted to file my affidavits. I've served copies on both the parties.
Yes, my lord, I got the affidavit.
There are two major issues brought here. One is that there are about 282 illegal occupant families there. And the other one is about the restoration and conservation. As far as the restoration and conservation, Lordship had directed me to file a detailed affidavit. I have filed a detailed affidavit, a report, including what I propose to do in the next 3 financial years, what I have already done, what I will do. But the issue of concern is about the illegal occupation, on which, my lord, the state government will have to take some action to move them. But I read the previous order. From there, we have not moved further. As Archaeological Survey of India, we can only provide the assistance, but the state government will have to use its machinery to ensure that the illegal occupants are removed.
Yes, we'll
Lord,
hear
sir.
it up. It will take time.
Please.
It will take time
This
after
will take
vacation. 2nd July. The affidavit filed by learned Reverend so and so is taken on record.
Please.
Send out to 2nd of July.
My lord, may I make
Serial
one
judge,
submission, my lord?
50 column.
Number 50.
I appear for the petitioner, my lord. Week's time may be
Yeah.
granted, my lord.
50.
Oh, yes. Senior not well, my lord. See.
No, senior is why? And every PIL senior is not well.
No, my lord.
All right.
R3 relating the documents is produced, not produced, my lord. This honorable court has directed.
Widening of highway.
Or
We'll go and widen the highway.
widening of road, my lord.
Where is the money?
Don't want to argue after vacation.
My lord, can I make one submission? My lord, I apologize. Serial number 9, my lord, which is passed over, my lord, which pertains to the challenge to Karnataka Religious Structures Protection Act, my lord, if I could make a request for after vacation, my lord. Learned Advocate General, it's an inconvenience today, so if my lord could have it. I've informed the other side.
For the petitioner, madam.
5th of June.
Obliged.
Leave to mention.
100, madam. A place for time, madam. Serial number 100.
100. Why it is kept at 2:30? All right. At the request of learned advocate for the appellant, stand over to 3rd of July as requested.
Leave to mention the matters in list 2, my lord. My lord had directed me to convert them to commercial appeals.
So,
My lord, the office objections are also complied with.
List 3, list 2, serial number 3 and 4. Third learned advocate Shruti Changanti for the appellant. Notice returnable on 13th June. What are the interim relief granted
My lord,
yesterday?
the interim prayers for stay of the arbitral award in respect of which execution proceedings are being presentated, my lord. The stay applications are part of the file now.
The proceedings of the
If the impugned arbitral award is stayed, my lord, the
learned advocate for the petition appellant stated that the execution proceedings have started and the notice for attachment of the properties are also issued. Full stop. In the facts of the case, in order that the irreversible situation does not arise for the appellant, comma, by way of interim leave, it is directed that execution the attachment shall not be acted upon
My lord.
as
If the-
directed by
if the arbitral
which is directed by the executing court
My lord.
till the next date of hearing.
My lord, execution 161 of 2025 and 162 of
And
2020.
MFA number 2727.
COMAP 190 and 209 and 210.
One second. This order will be same in 3 and 4. Then MFA seal number 1 and 2, MFA 2726 and 2777, 2727. Learner review so and so seeks permission to withdraw the present MFA in view that the same is permitted to be converted into commercial bill, which is today posted on board, and the order is passed therein.
Serial number 73, my lord. To dispense the notice to R4, the R4 is, A4 is the formal party. Serial number 73, my lord.
No delay. There is a delay then.
My lord, the issue is that there is a pure question of law involved, my lord.
It is
as to
not
whether-
the question.
My lord. Well, the objections have been complied with, my lord. The applications are on record.
Where is delay? Not listed. Then let the all go to Tuesday. On Tuesday, ask the order.
My only submission, my lord, is
Order.
that attachment warrant through special amina has been
To
issued.
stand protected till Monday. The interim leave granted earlier in MFA may I, the order granted earlier shall continue to operate till 22nd. All matters to be listed, all board to be listed on 22nd. It was stated that contempt, the delay applications filed in the commercial bill, which shall also be listed on 22nd. You give copy to other side and get it if you are really need urgent orders.
My lord, I may be permitted to serve the local council.
Pass over matter, seal number 42. Mr. Ranganath R. Number 42, Mr. Ranganath R.
Was to remove the impression of work land subject to outcome of SLP matters, which we have done.
Learned advocate for the petitioner. Mr. Ranganath R is not present. Full stop. Learned additional government advocate. Mr. Navin Chandrasekhar stated that the submitted that the order is complied with. Full stop. The contempt petition shall be listed on 23rd of April. Where is the order? Which directions are the page?
Page 17 matters. Para 4 matters. That we have done the same.
No, SLP has ended.
We have entered the pendency of SLP and removed the name of the document. It's subject to the outcome of SLP. That's the direction as such. Para 4 at page 17.
The following directions in the order of Learned Single Judge dated 27 September 2023 are made subject matter of the present contempt proceedings. Report paragraph 4, page 17. Compliance certificate is filed, to which attention was drawn. Attention of the court was drawn by learned additional government advocate, Mr. Navin Chandrasekhar, to point out that pending the SLP before the Honorable Supreme Court, in due deference and respect to the orders of the High Court, in attention of the court to the compliance certificate, in it stated that by virtue of order dated 27/8/24, bearing number MRT 15, published 2013-14, the entry of Wakaf board at column number 11 is deleted. Same is made subject to, the deletion is made subject to the outcome of the SLP, which is pending pertaining to the said land before the apex court. Full stop. In that view, the order of Learned Single is complied with. Nothing survives in this contempt proceedings. It is disposed of. Since learned advocate petitioner was not present, even in the second court, the proceed order is passed, disposing of the petition as the order is complied with, it is delivered for the petitioner to revive the contempt if required. If genuine ground exists. If genuine ground exists. Same order in second matter.
Very much more.
Identical order in second matter.
Petition number changes.
Same.
Petition number changes.
SLP number.
Petition number, writ petition.
SLP number in English.
It's number 44, Mr. Veerabhadra MC.
Compliant, my lord. We are also filed the memo along with allotment letter, my lord.
Site is allotted.
Allotted, my lord. Allotment letter also issued to the complaint, my lord. Allotment letter also issued to the allotment complaint, my lord. Copy also served to the other side.
Which site is allotted?
I'm sorry.
Which site is allotted? Which site is allotted?
We are allotted site number 13, my lord.
13.
Earlier 806 in the same layout, alternative allotment they sought. We are allotted in the same layout, site number 13, my lord.
13. By order dated 18th February 2016 from a learned single judge, directed the respondent Bangalore Development Authority to take a decision within stipulated time regarding alternative site to be allotted to the petitioner in the same area and of similar dimensions. In the affidavit filed in the contempt proceedings, the petitioner stated that site number 13 in the first block of Pora Mangala is vacant and that the same is not allotted to anyone. Also, the compliance affidavit, the respondent has filed memo dated 26/3/15, along with which allotment letter dated 25/3/25 issued by the Deputy Secretary -1 is produced, which reflects that site number 13 is allotted to the petitioner. Full stop. The above marks MARKS compliance of the direction of the contempt petition does not survive. It is according to this code.
Number 47, Mr. Lakshmi Menon.
46 also. None is present for the petitioner. Stand over to 9th of July. When it is coming. So none is present for the petitioner. Stand over to 9th July.
Number 96, Mr. Nityananda Nayak.
You mentioned 95, 94. You can take 94. 117.
94.
Yes, any urgency?
The matter
Yes,
was
my
heard by your
lordship
lordship.
wished to afford me an opportunity to make the submission, my lord. After hearing the matter, my lord, at length, my lord, I filed a memo also, my lord. And, in fact, orally it was mentioned that orders would be passed.
This was heard that family.
Lordship had heard the matter. Matter relates to rehabilitation compensation. my lord.
We are closing the proceedings.
Please.
This order.
Please.
The order of the learned single judge in WP 23106 of 2015 dated 16/3/22 is set aside. Respondent 2 is directed to consider representation dated 6/4/2015 in the light of the letter dated 5/2/2015 at Annexure J issued by the Office of the Conservator of Forest and Director, Bhadra Tiger Reserve, Chikmagalur, as well as the partition deed dated 6/5/1998. The above directed exercise shall be completed within a period of 10 weeks from the date of service of this order.
Great.
Bill number 94. Mr. Naveen Gudikoti.
I appear for the respondent, my lord, contesting respondent. I have filed this application for modification of the interim order because the elections are held for the post of treasurer in pursuance of the order in the writ petition on 9/8/2024, my lord. The results are to be announced, but there is an interim order of this honorable court that it shall not be announced without the permission of this honorable court.
Who appears for other side?
Please, my lord. My lord,
Who appears for other side?
one Naveen appears, my lord. He also was here when I mentioned in the morning.
You should have informed him.
Yes, my lord, he was here, very much here when I mentioned, and I also informed him that I'm going to mention. And
So what order is passed in this appeal presently?
my lord, on 8/8/2024, the order is passed by this honorable court, my lord. Since the calendar of events were already announced, the election was to be held on 9th, my lord. That was the date fixed. So this honorable court passed an order that the elections shall be held as the calendar of events are already announced, but the results shall not be declared. That's the interim order of this honorable court on 8/8/2024, my lord. My lord, in the end of the order, the operative portion is there. However, it is directed that
Come with the other side. In absence, how can we proceed? Inform that court has accepted a request for.
please, my lord, I will inform him now itself. And
Keep it on 20. Keep it on 21st. 21st.
this 21st, my lord. My lord, time may be fixed as 2:30 so that this.
You come with the other side.
Yes, I'll inform him today itself. Kindly direct the office to list at 2:30, my lord, so that there will not be any further confusions whether it will be taken up or not. So But every time I'm mentioning it at 10:30, even I'm also feeling somewhat embarrassed to make this such a submission every time, my lord.
10:30.
2:30,
All
my lord.
matters at 10:30. In seriatim. All matters to be taken at 10:30 in seriatim.
My lord, please, my lord, a humble request,
We are also saying humble.
please, my lord. At least in hearing on IA, it may be posted, my lord, because my IAs have to be considered.
We have taken up acceding to a request.
My lord, it's listed for final hearing. That's the reason.
We do not know how we'll take up. We'll take up the matter. That much I know.
Again, I will have to mention, my lord, otherwise. Please, my lord, I'll inform the other side. Please. 21st of this month, my lord.
So, number 97. So withdrawal of writ petition. It's appearing for petitioner's merit. Appearing for petitioner's merit. Humble request to withdraw the dismissal as withdrawn. Present petition.
Dismissed.
And no, there is no like specific reasons, my lord.
Figures on record. Memo dated 18/3/25. Filed by the counsel for the petitioner, in which the permission is sought to withdraw the presented petition with a liberty of 5 fresh. Why?
No, without liberty.
No, that is not necessary.
No. It's up to
Petition
court.
dismissed as withdrawn.
So number 98. A. Madhusudan Rao.
In this case, my lord, rendering a check, my lord, for 2 months' salary.
Check is brought.
66,000 crores. Pending amount has been, it has been correctly calculated.
So it is over.
Over.
Yes,
Contempt is over.
yes.
Fully complied.
Subject to realization of it.
On last occasion, on the previous occasion, this court had an occasion to pass the following order dated 7/4/25. Quote the order. Today, when the contempt proceedings came up for consideration, Learned Advocate Mr. So-and-so, the respondent, has physically handed over the check or draft. What is
Check,
it?
my lord.
Check bearing number.
975,434.
Give the details. 4 rupees.
Copy the
4 rupees. For how many? For
66,132.
152.
152.
One?
66,152.
1,66,000.
No, no, not
66,152. my lord.
66,000.
152.
152. Towards maintenance.
No, my lord. 2 months' salary.
2 months salary. my
2
lord.
months salary. Full stop. Which is handed over to Learned over the petitioner to be further handed over to the petitioner.
Yes.
Full stop. Learned advocate for the petitioner has accepted the same. In the aforesaid view, the contempt petition does not survive as the order is complied with, as the order of Learned Single is complied with. Proceedings are dropped
Much.
and closed.
Much.
Closed and dropped.
So number 99. Mr. Tilak Raj SP.
For R48, my lords. This I appear for the petitioner.
I appear for R25. I appear for respondent 25.
Yes, who is for the petitioner?
I appear for the petitioner, my lords. My apologies for now being unable to appear on the previous occasion. We were attempting to log in through the VC, my lords, but the virtual platform had changed and we contacted the technician. We had to freshly register. By the time we logged in, my lords had already passed an order.
You called technician.
Yes, Mr. Muralidhar. Mr. Muralidhar.
Where did you call? Here?
My lords?
Where did you call the technician? In the court or in your office?
Over the call, my lords. Over a phone call.
Phone call to your office.
To the technician, my lords.
Where he technician came where? Technician came here.
No, my lords, we were unable to log in, my lords.
At
to the
your
VC.
office he came.
No, my lords, we made a phone call.
Phone call. What happened?
We were asked to freshly register because it was Zoom previously. Now it's on vConsole. The virtual platform had changed. And by the time we could appear physically, my lords had already
Now
passed.
it is working.
Yes, my lords. Please.
Your
my
mind
lords.
is also working.
Yes, my lords.
You
Please.
paid to the.
It will not occur
Payment
again.
is made to the technician.
My lords.
Payment is made to the Payment is made or not to the technician?
No, my lords.
Not made. So make it. Pay whatever amount he is charging, you pay. But now you argue. You are
No,
slowly
my lords.
seeking time.
No, my lords. The
That you-
senior counsel
Slowly,
engaged.
slowly you are going towards request of time.
No, my lords. No,
You are arguing?
that's not. No, my lords. I was instructed to seek time.
Ah, that is what exactly we told. Very cleverly you are seeking time.
No, this is the very first occasion.
Whole technician then said that we had a phone call
No, my lords. This is the very first
that
occasion.
we did pay something to this technician. Then you said that my mind is now working after technician has repaired it.
No, we filed our rejoinder, my lords. The state has filed its objections.
Technician repaired what? Technician repaired your phone or PC or what? What?
No, the login credentials, my lords. The
Login in. You want to log in your mind.
There's a rejoinder.
Tell me what is to be done, Mr. Let us,
We don't have a-
don't waste time.
Please, my lords.
What is this? Writ of co-warrant. Ah, this is very important matter. Last time also order is passed.
Please, my lords. That's the reason I mentioned I conveyed my apologies right in the beginning
That
for not
apology
being able to
granted,
appear.
but today very important matter. Tell me what is the point?
No, my lords, the state has filed its objections, to which we have filed our rejoinder this morning.
Not necessary. Argue. Chal.
We filed statement, he's filed a rejoinder to that. We haven't filed the statement. Sorry, madam. We haven't filed a statement. I don't know how he's filed how he says he's filed a rejoinder. So I got confused with that.
You have served a copy upon us.
Who has-
Over email.
I'm sorry, my lord, it's filed.
I think ma'am meant rejoinder.
No.
My lords, we filed our rejoinder. We'd like to
And I
address.
don't have a copy of the rejoinder.
It's been served by. May I pass this on, my lords, for the court? It's been
You
filed.
want to give us, then pass it.
My lords, it's filed, but it's not tagged. So I'm carrying additional copies for the court. My lords, the rejoinder is filed, but it's not tagged yet. So I'm carrying physical copies for the court.
In the last minute, you don't say statement is filed.
Yes.
Ma'am.
I'm sorry, my lord.
We are waiting. Who is asking for time for this?
No, my lord, I'll move for time because my lord, service is not complete on all the respondents.
Not complete.
No, my lord.
19
Other
respondents
respondents
are-
have to be served.
My lords, the addresses stated are is stated as it is in the website of the Legislative Assembly. On 21st, my lords ordered hand delivery also. Accordingly, we approached the speaker because their conduct of business, it states, any legal issue, any legal process must be served only after obtaining the permission of the speaker. Accordingly, we made a
We
requisition.
will not permit you to utilize this petition as pressure tactics. As a pressure tactics, we will not utilize, we won't permit you to utilize this petition.
No, that's not the intention.
So we are watching since last 3 occasions that you are not arguing after getting notice.
No, my lords, this is the very first occasion I was instructed.
No,
to
it
take
is second time at least, minimum. So if you file such a petition of a very highly constitutional political nature and sit tight, we will not permit you.
My lords, the senior counsel wishes to
That
argue
is no
this in.
reason, whatever the reason, but you have to proceed with the matter.
My lords, we will.
If you are misutilizing the proceedings for some oblique motive, we will not permit.
No, that is not the intention. My
It
lords.
appears to be
a
so.
short date. My lords, he wishes to appear in person. May 1st, my lords. May 1st.
No, no. May 1st, who will come?
My lords, any short date, my lords.
May 1st is a Labor Day. We will all take rest. All right.
The shortest possible date, my lord, subject to your lordship's convenience. Shortest possible date.
Yes, madam.
Not any day, my lord, please. Immediately on the reopening, my lord, after reopening.
At the request of learned counsels for the parties, 10 over 2. Tenth of June.
Obliged.
Full stop. In the meantime, the service shall be effected on the unserved respondents, the petition.
I'm so grateful.
100 is adjourned. 101 to Jayanth V.
Yes, but why it is listed at 230? That same type of order to.
Well, same cluster in fact. Look,
Same type of order to be passed.
same type of order, yes.
Who appears? But notice is not issued.
My lord, it's covered, my lord, cluster matter.
At page 20 minutes. First
Page
20 is the cluster map.
20.
Annexure B.
That cluster
Cluster matter. Maybe disposed of on similar
on the
terms.
same line.
Yes,
Fit.
obliged.
Cell number 51 with Varsha R. Iyengar.
None is present for the petitioner. Stand over to July.
My lord, in this I'll file an affidavit.
In fact, this can be disposed of, but nobody.
My lord, my lord may take my affidavit on record.
Learned additional government advocate, Srimati Nilofer Akbar, files affidavit, which is taken on record, full stop. None is present for the petitioner. In the larger interest of justice, to be listed on 15th July.
Obliged.
Cell number 52 to Deepak Bhaskar.
So if you have for the petitioner, this is a petition preferred in public interest on account of the rampant commercialization of a purely residential area in Bangalore. This honorable court had, by way of an order dated 15th March 21, directed a spot inspection.
For respondent, my lords, kindly pass over, my lords. Seniors in another court, kindly pass over, my lords.
So not possible.
If your lordship will just see the objections filed by the BBMP, there's something very troubling. My Lord will have it dated 22nd February 2025. My Lord will please see paragraph 3 of their objections. May I read?
No, take.
My Lord, paragraph 3 of the BBMP's objections dated 22nd February 2025, they state as follows. It is submitted that of the many commercial establishments which have not closed down, paragraph 3, it is submitted that of the many commercial establishments which have not closed down have been running said operations for many years, and when our officers, even with the support of the jurisdictional police, have faced a lot of resistance and retaliation from the public against the closure drive, it is submitted that even as recently as 23/11/23, when our officers visited the spot to carry out the closure drive, post issuance of notices, there was huge public furor, even with the police present at the spot. To avoid any public unrest and untoward incident, our officers were forced to retract from the said closure drive. Then please see paragraph 7. It is submitted that at the outset, we respectfully submit that we have the highest regard for this honorable court. We are duty bound to comply with the directions issued by this honorable court. We submit that we have always obeyed and will always continue to obey the orders passed by this honorable court. We tender our unconditional apology for any delay that may have been caused in complying with the orders passed by this honorable court. It is submitted that with all due respect to this honorable court's order, we are endeavoring to implement the rules and regulations prescribed in RMP 2015 in a phased manner. It is submitted that on sudden implementation of the rules and regulations, there is high chance that the public are agitated, unrest, and it may lead to civil commotion. The master plan was issued in 2007. 18 years later, they say that they are still unable to implement it.
Lords, may I make a submission, my lords? My lordship's kind permission. Lords, these were pointed out on the last occasion also, my lords, and my lordships were unhappy with the affidavit that was filed, my lords, and had asked us to take the notices further, my lords. So, my lords, further notices were issued, my lords. Further notices were issued, closure notices in January 2025, my lords. There are many commercial establishments that have self-closed. They have voluntarily closed their establishments, my lords, and there are certain establishments who have placed their objections, my lords. So a hearing is being held and orders are being passed, my lords. Those also I will produce it on the next date of hearing, my lords. If my lordships may kindly permit 4 weeks time, my lords, I'll show the progress that has taken place.
So if your lordship please sees the order sheet. This has been their submission since the institution of the petition. On one pretext or another, my lord, time has been sought.
Lords, not on this pretext, my lords. Sorry, my lords.
What you are going to produce? Orders regarding what?
Hearing that has been that are being held, my lords. My lords, there are objections from certain commercial establishments, my lord, telling that it is within the permissible limits. 40 feet road is there.
About this affidavit.
Sorry, my lords.
About the affidavit you have filed.
My lordships were unhappy with the in the affidavit on the last time itself, my lords. The petitioner had pointed out, my lords. So, my lords, a better affidavit would be filed, my lords. It was the undertaking that was given.
No, my lord, this is the better affidavit. In fact, the objections were first filed in 2021. This is a subsequent iteration after your lordships expressed displeasure with the previous affidavit. If I may just pass on, my lord, 2 judgments of the Honorable Supreme Court on this point. In fact, there is a previous decision of a division bench of this honorable court in Writ Petition 3676 of 2008, where the issue of the planning authority and unauthorized establishments was considered. And my lord, may I just pass on this judgment? My lords will please have paragraphs 74 and 75. At page 743, paragraph 74 reads as follows. In the last 4 decades, almost all cities, big or small, have seen unplanned growth. In the 21st century, the menace of illegal and unauthorized constructions and encroachment has acquired monstrous proportions, and everyone has been paying heavy price for the same. Economically affluent people and those having support of the political and executive apparatus of the state have constructed buildings, commercial complexes, multiplexes, malls, in blatant violation of the municipal and town planning laws, master plans, zonal development plans, and even the sanctioned building plan. In most of the cases of illegal or unauthorized constructions, the officers of the municipal and other regulatory bodies turn blind eye either due to the influence of higher functionaries of the state or other extraneous reasons. those who construct buildings in violation of the relevant statutory provisions, master plan, etc., and those who directly or indirectly abet such violations are totally unmindful of the grave consequences of their actions and or omissions on the present as well as future generations of the country, which will be forced to live in unplanned cities and urban areas. My Lord, may please turn over to paragraph 75. Unfortunately, despite repeated judgments by this court and the high courts, builders and other affluent people engaged in the construction activities who have over the years shown scant respect for regulatory mechanism envisaged in the municipal and other similar laws, as also the master plans, zonal development plans, sanction plans, etc., have received encouragement and support from the state apparatus. As and when the courts have passed orders or the officers or local and other bodies have taken action for ensuring rigorous compliance with laws relating to planned development of the cities and urban areas and issued directions for demolition of illegal unauthorized constructions, those in power have come forward to protect wrongdoers either by issuing administrative orders or enacting laws for regularization of illegal unauthorized constructions. But our case is only this, that there is a master plan which designates our area as a purely residential area. This honorable court had directed a spot inspection to be conducted. The spot inspection, my Lord, virtually affirms the contents of my petition. My learned friend's affidavit also confirms the averments that we have made. We're only, my Lord, seeking expeditious redressal of our grievances. My learned friend has, on one pretext or another, sought time, my Lord, since the institution of this petition. The order sheet will bear me out.
Where is your affidavit?
Affidavit was filed on 19/2/25, my lords.
19/2/25.
Please.
This is the only affidavit.
My lords,
No,
this
there are previous affidavits that are filed both by the BDA as well as the BBMP. The BDA shockingly says that it is not responsible for town planning when in fact it is the planning authority. All of the documents which my learned friend has annexed with his statement of objection, my lord will see the dates. This is 7th January 2023. The notices that have been enclosed, these are all 2023. Nothing has moved since. Instead, on the ground, my lord, virtually, the area has been transformed to a commercial layout. And the petition, my lord, becomes fait accompli.
If my lordships permit, my lords.
Statement of objection said, of which date? The statement of objection filed by you.
Please.
There is no date. Filed on 19/2/25 and 22/2/25.
If my lordships are pleased, my lords.
My lords will also see there was a previous statement of objections dated 26/3/2024, which is virtually identical. The same contents have been placed before my lords here. So the same paragraph which I read out to my lords.
In the present you are in trouble.
My lords, if I may be permitted, my lords, on 15th January 25, my lords. If I'm not wrong, my lordships are seeing the same affidavit twice, my lords. It is because one is with the translated copies, my lords, and one is without the translated copies, my lords. My lords, on 19/2/25 that is filed, it is with translated copies. My lords, both the affidavits are identical, my lords. It is one without the translated copies, one with the translated copies, my lords.
So why you are filing two affidavits? Why?
Sir, my lords, if one is with the translated copies, my lords. One is with the translated copies, my lords, of the notices that were issued. One is earlier without the translated copies that was filed across the bar, my lords. My lordships had requested that directed me to file the translated copies, my lords. As such, the translated
We
copies.
never said translated copy. It is for your responsibility to file.
Please, yes.
So why you are filing two affidavits?
Lords, it is the same affidavit, only one with the translation, one without the translation. My lords, even on January 2025, my lords, we have issued fresh notices, my lords. I'll place the progress report on this, my lords. If my lordships were permitted, if my lordships permit, my lords. Sir.
So in fact, if I may just point this out, at one of the previous hearings on examining the contents of this statement of objections, my lords had expressed a view, perhaps, that any further commercial establishments ought not to be. No orders have been passed. No orders have been passed. My lords had directed that the objections, an affidavit be filed with the view to perhaps examining whether any further establishments can be allowed to carry on business. The difficulty otherwise, my lord, is
Who has drafted this affidavit?
Sorry, my lords.
Who has drafted the affidavit?
Lords, the affidavit was drafted by us, my lords. So some corrections were made by the MOH, my lords, by the health officer, my lords.
Anyway, who has affirmed is the responsible officer.
Lords, my lordships had directed me to file a better affidavit along with the progress report, my lords.
So
My lords,
which is
January
which
2000.
was not better affidavit?
No, my lords. My lords, the affidavits are the same, my lords. One
We
without-
directed to file the different affidavit, other affidavit.
Yes, my lords.
Which is the previous affidavit?
My lords, both the affidavits are the same, my lords.
Same.
Same, my lords. One without the translated copies, one with the translated copies only, my lords. The better affidavit, my lords.
As you are saying that we wanted you to file a better affidavit.
Please, my lords.
Where is that better affidavit?
My lords, exactly, my lords, my lords. 4 weeks accommodation, my lords. With the progress report, I'll file it, my lords. With the progress report, I'll file it, my lords. With what progress has taken place.
Put on progress report.
My lords,
In
January
fact, on
2025
26
also, my lords, we had issued.
Why we required you to file a better affidavit?
My lords, because there was this para number 3 and para number 7 had to be omitted, my lords. Yes, my lords.
So you have not omitted so far.
My lords, I'm seeking an accommodation of 4 weeks, my lords, to file it along with the progress, my lords.
in fact, on 26th August of 2021, they have conducted an inspection of the premises and filed a report. And since 21 to 24, my lord, nothing has moved.
The issue flagged in this public interest petition is in respect of the mushrooming of commercial establishment in the city of Bengaluru, which have come up contrary to the, in breach of the provisions of the master plan and in violation of construction regulations. Responding to the case. An affidavit is filed dated 10/12/24 by one Bhagyalakshmi and Bhagyalakshmi. What is the BHAGYLAKSHMI? Bhagyalakshmi.
Health officer, my lords. Health officer East.
Health officer.
Please.
Health officer of the BBMP. This one hearing. In which she inter-alia stated thus, page 3, paragraph 3. Is to be quoted. The above governments invariably go to show two things. Firstly, the BPMP accepts that there have been encroachment. Secondly, the governments miserably reflects the lack of will on part of the BBMP to enforce the law. It is stated that buckling under the public pressure from the officials of the BBMP retracted from carrying out the closure drive against the illegal buildings, illegal constructions.
It's commercial establishments.
Full stop. Noticeably, another affidavit, it is same.
Please, my lords. My lords, the affidavits are the same, my lords.
The court will consider taking stern view in respect of the governments and the stand taken by the BBMP in the aforesaid statements and averments. The affidavit further says that notices were issued to the airing establishment in the year 2023 and early 2024. However, accepting the issuance of notice and producing them on the record of the present proceedings, it appears that the authorities of the BBMP are either complacent or are non-willing to take the notices to their logical and in accordance with law, and to take measures against the establishment who have come up in violation of the building regulations. While learned advocate for the respondent BBMP pressed for time to file further affidavit, it is directed that in the further affidavit which is filed, unless the concrete steps are indicated to have taken by the BBMP against the establishment who stand in the violation of the building rules and regulations and the building plan rules and regulations. The court will take a stern view. Full stop. In the affidavit to be filed as above, the contumacious and deprecate the stand which is highly deprecable. In the affidavit to be filed, comma, the deponent shall explain the conduct of making the averments duplicate averments as above to be reproduced herein above from paragraph 3 of the affidavit. As to on what as to whether as to why the proceedings in accordance with law should not be initiated against the deponent of the said averments. Full stop. Put upon when 20
June last week, if I may request, my lords. June last week, if I may request, my lords.
25th June last
After post.
this 25th 26th then 26th of April.
Yeah. Lords, may I request on 28th?
At least you can be take careful in drafting the affidavits. These are not the empty statements or empty pleadings.
May I make one request, my
The
lords?
sanctity of law, yes.
On 28th, if I may request, my lords. 26th, I have some personal inconvenience.
29.
Please. Great.
Number 53, Srimati B. Vidulata.
I appear for the petitioners, my lord. I pray my lords for a short accommodation.
53. What is it about?
And also I have to file my synopsis, my lord. I am respondent number 4 in this case. My lordship directed us to file the synopsis, my lord, in the last date of hearing. Synopsis are ready, my lord. I will serve and I will file the synopsis.
So, line 5. Learned advocate so and so request for time stand over to 26th of June. Learned advocate Mr. So and so for respond number
4, my lord.
for files what?
Synopsis, my lord.
Synopsis which are taken on record.
This is number 54. Mr. Venkata Muni Shetty K. Number 54. PA.
None is present for the petitioner. Stand over to July 11.
This is number 55. So PAL. Mr. Shanmuka GC.
My lord, in this, I seek for a short accommodation to Tuesday, my lord.
I know. No, there is no time.
55.
55, what do you say?
My lord, a short accommodation till Tuesday, my lord.
It will go long now, 8th of July.
Obliged.
So number 56. PAL.
Please, for the petitioners. The issue raised by the petitioners is to construct a service overbridge across a river in the outskirts of Madur town, wherein the National Highway Authority has constructed a 10-lane highway recently, which is finished and inaugurated about 2 years back. Lord, as per the memo which is filed by the National Highway Authority for doing after filing of this writ petition, one side service lane bridge is constructed. My Lord, to explain the grievance of the petitioners, my Lord, I would like to draw my Lord's attention to the photograph which is produced along with this petition, page 156. Lord, may kindly take note.
Photograph.
Please, at page 156, annexure G.
Page
Lord, 156, my Lords. Please, Lord, this is the place in the outskirts of a town headquarter, Madur, in the district of Mandya. The river which is flowing is a tributary to river Kaveri called Shimsha. Lord, the construction which is taken by the national highways is only for express highway, which is access controlled highway. And my Lord may kindly notice the either side of this highway, the service lane has been open to the river, and the national highways has not taken any action to construct. How to the people who are proceeding by using the service lane, how to proceed next? Lord, even after representations, the national highway has not taken the task, and ultimately the writ petition was filed. Lord, subsequently, the national highway has constructed, bridge across this river in respect of a service lane on one side. After constructing this one side bridge, my Lord, a memo is filed that the grievance of the petitioner is made out and the matter could be disposed. So this is, my Lord, my submission is that this is a partial completion insofar as the lapse, which is the bounden duty of the national highway, which is to observe. Lord, subsequently, my Lord, the petitioners have come across identical lapses committed by the national highway across the newly built the national highway 275, wherein at 4 stretches, my Lord, the Bangalore-Mysore railway lane, which is a double lane which intersects the national highway 275. Lord, Lord, in the application for amendment, Lord, we want to, increase the scope of this petition because identical lapse is committed wherein I request my Lord to visualize instead of river the railway lane beneath. I request my Lord to kindly take note of the application which is filed seeking amendment of the writ petition, wherein we need to add certain facts and prayers are also sought in respect of when the photographs are also produced at page 12, 13 and 14 in the application, my Lord. The national highway has stopped for construction of the rail over bridges on these 4 points. Now, my Lord, making the users of the service road to they will come at a standstill and they doesn't know how to pass. My Lord, in case of night time, if a service road user has to stop here, my Lord, it will result in not just the inconvenience to a motorist but also safety aspect. My Lord, giving priority to the express highway and ignoring these aspects without considering constructing the rail over bridges in 4 points, which is the mandate prescribed in the Indian Road Congress guidelines, and which is the binding on the national highways.
You filed some memo? Who has filed memo?
The national highways has filed memo.
May I just draw my Lord's attention to page number 15 of the writ petition at clause D. My Lord has clause D on page 15. It says the IRC specification 2019 for 4-lining of highways at 2.12.2.2 says as follows. For stretches where total length of a bridge is less than 60 meters and service road is required to be provided on both sides of the stream, then service road shall continue across the stream and suitably designated two-lane bridge structure shall be provided. In cases involving bridges of 60-meter length or more, separate bridge structure may not be provided. And service road shall merge with the project highway at 50-meter distance before the bridge structure. The bridge in this case, my lord, is 240 meters in length, longer than 60 meters. Despite that, based on a representation that was made by the villagers, a service road has been constructed, my lord, and I filed a memo to that effect on 10/4/2023. Their prayer has been worked out, my lord. The prayer in the writ petition is fully worked out. After I file a memo on 10/4/2023 stating that service road construction is underway, only in order to keep this writ petition alive, the amendment application has been preferred. My lord would see that mandamus is sought for, but no representations have been made to the authority in that regard. In any case, in my statement of objections, I refer, my lord, I filed my statement of objections also on 10/4/2023. If my lord would see on page 2 of my statement of objections, if I may take my lord to paragraph 5 of my statement of objections at page 1.
Statement of objection dated
10/4/2023, my lord.
It's for the application regarding amendment.
No,
Not the objection.
No, the objection to the main petition, my lord. I have filed objections to their application also. I filed it to both. I filed it to both. Sir. My lord would have paragraph 5. May I, my lord? My lord has paragraph 5. Similarly, in each of the railway crossings referred to in the application filed by the petitioners at Bidadi, Channapatna, Umadahalli and at Indvalu, the bridges over the railway crossings are over 60 meter in length as seen from below.
where you are reading?
The statement of objections, my lord.
At which page?
My apologies, my lord. I think their objections to the application for direction that my learned friend had filed, in that at paragraph 5, which is also filed on 10/4/2023. In that application, they had already referred to these railway. Paragraph 5, my lord. May I read, my lord? Similarly, in each of the railway crossings referred to in the application filed by the petitioners at Bidadi, Channapatna, Umadahalli and at Indvalu, the bridges over the railway crossings are over 60 meter in length. Therefore, per the IRC guidelines, my lord, if the bridge is over 60 meters in length, the service road would merge 50 meter on the project highway prior to this commencement of the bridge structure. My lord would see this is an access controlled highway. For that reason, we do not give end-to-end service road connectivity. But on the basis of submissions made, of representations made by villagers, as far as Shimsha River Mandya goes, we have given a service road. For Maddur, a change of scope had already been preferred, my lord, with respect to constructing a service road there. Also, my lord would see that in Bidadi, Channapatna and Maddur, what the National Highways has done is they've avoided the old highway and they've constructed a greenfield extent in those stretches, so that the old highway gives connectivity to the villages. The application for the prayer in the main petition is fully worked out, my lord. As far as the application for amendment is concerned, it has only come about in order to keep this writ petition alive.
My learned friend is pointing towards the petitioners that we want to keep the KIL alive. This is not the intention. Even my learned friend has drawn my lord's attention to the IRC guideline, which is incorporated in the very memorandum of writ petition. But the intention behind this particular guideline is that, even according to the explanation given by my learned friend, if the bridge is more than 60 meters, then the service line has to merge. If such being the case, then there is a provision should be made for the service lane users to, use the express highway, which is not the case. My lord, it is an access control, and the user of a service road cannot at any point of time, it can enter into the main highway. But the same kind of errors are committed while at 4 points where the railway line intersects the national highway. But how come the national highway can ignore? Lord, I would like to pass on the IRC guidelines, even insofar as the construction of the rail over bridges. May I pass it on?
Whatever you want.
To explain the situation, my lord, kindly in the application for amendment at page 12, I have mentioned one junction, Dodmalur. My lord, between Biddi and Dodmalur, this is the, a stretch of about 35 kilometers. After crossing 35 kilometers in the service lane, my lord, a motorist will be, stopped here. There is no provision made for crossing over the railway lane.
So that will take up on 23rd, will take up, give for it. Third.
So please.
This is number 57, Mr. Gautam Sridhar.
On the earlier date, this matter pertains to encroachments of lakes in the Hubli-Dharwad region. On the earlier order, my lords, on 19/12/24, my lords are directed that they file a report. The DC files a report within 8 weeks. My lords, till today, the report has not been filed, my lords. We are awaiting the report.
My lord, I seek for some time, my lord, in this. I haven't received instruction.
My lord, the report was to be filed within 8 weeks. It's been 5 months, my lords.
I've written, my lord, but there's no response. They are seeking for removal of encroachment from 5 tanks.
We're supposed to file report.
My lord, immediately on a reopening, I'll file it, my lord. Necessary application. I apologize, my lord.
Report is contemplated in order 19/12/24 is awaited, yet to be, and is yet to be filed. Learned additional government reviews within the Nilo for work place for time. For the purpose, stand out, full stop, stand out to 6th of June.
Obliged.
Grateful.
This is number 58, Mr. Ban Prakash PG. Appearing on behalf of the impleading respondent, Your Lordship. Impleading respondent. Appearing on behalf of the impleading respondent, Your Lordship.
On behalf of?
Impleading respondent number 7, Your Lordship.
Where is this? Nobody is there. 9th of July.
This is number 59. It's a writ petition PN, Mr. Murali BS.
Petitioners.
matter pertaining, Lord, matter pertains to, my lord, the illegal encroachment of the land and road, my lord, by the private respondents. But there is a report, my lord, by the authorities pertaining to the said encroachment. Lord, representation is made by the petitioners seeking removal, my lord, of the said encroachment of the public road. And there is a report, my lord, also submitted by the Tahsildar, which is placed on record.
Who is opposing?
I appear for the respondent. 4, 5 and 8 below.
So come physically.
Please.
June 27.
6.
Please.
Number 60.
Oblacha.
Petition PAL. Vijay Kumar L.
None is present for the petitioner. Stand out to 18th June.
Number 61. Yatish KJ. PAL.
Here for petitioner in this case. Your Lordship, the objection regarding office objection regarding
Replies.
annexure A3. Office objections are raised regarding annexure A3, A4 and A5. Better copy to be filed. But the petitioner has collected this document, received this document through concerned authority to RT application. Same has been produced before this honorable court. Kindly override that 3 objections. All 3 copies are the certified copies issued by the RTI.
Notice returnable. 30th June.
Number 62. So Vignesh G.
My lord,
62.
this is a matter ongoing in NGT, my lord. There is a demolition order issued for illegal construction on the beach of Karwar. Illegal construction of a hotel. The hotel owner had appeared in Dharwad bench and sought a stay for the demolition order. So I got it transferred to the green bench here, my lord. This is the first time I got hearing. And this stay may be vacated because the authorities have kept everything on hold. Even the case in NGT is kept on hold because of this stay, my lord.
Who is for the petition?
Petitioner is the owner of the hotel lodge. Owner of the illegal construction.
Where is he?
He is not appearing, my lord.
So he has to be heard before any order in the past. Wait till vacation. 10th July.
Number 63.
Obligement.
Ravindra Gajana Kolle.
Please, my lords, herein an objection, office objection has been raised, my lords, stating that copy of the statement of objection has not been delivered to me. In fact, it has been sent to me through email, my lords. I acknowledge having received a copy of the statement of objections, and that objection may kindly be waived off, my lords, in the first instance.
So reply is filed.
Lord, reply is filed, my lord. My lord, it was filed in the office on 7th November 2024.
So get the reply. You got the reply?
Beg your pardon? No, I will not file any rejoinder, my lords.
No, you got the reply.
Yes, my lords. I got it.
7th November.
Because only a short point is under consideration. the impugned notification issued by the C&I secretary, that pertains not to QL applications. Because what happened was the approval of the state government may be necessary insofar as applications which were issued with grant notification post 73/2023, whereas my query lease application was filed in the year 2014, revenue NOC was received, forest NOC was received, and technical report was received earlier to 12/8/2016. Thereafterwards, a grant notification has also been issued. Thereafterwards, my lords, under a mistaken impression, they say that approval of the state government is necessary to execute the lease deed, which according to my humble submission is only an administrative job or a ministerial job as per Gujarat Potteries case, my lords, which my lords very well aware of. So to that extent, the permission of the state government may not be necessary. And also, my lords, another important factor that is coming in the way is in the Gazette notification, if I may draw my lord's attention to page number 29 of the reply filed by the state, my lords.
My lord, may be called, my lord, next week, my lord. I haven't prepared myself to argue before, my lord.
Notice notification 19/117.
Yes, my lord. Therein into bracket that has been into. I don't know how that is enforceable.
25th.
My request to you, my lords.
Pardon?
After vacation, it
After learned advocate for the petition wants time, stating that the petition may be listed after vacation, stand over to full stop. Accordingly, it will be posted on. When do you want? 13th June.
Please, my lord.
Number 64, Mr. Guru Prasanna S.
I appear for the petitioner, my lord. This is a writ of mandamus seeking direction against the respondent authorities from permitting the respondent number 3 who is carrying out industrial level activities in the residential zone in violation of the zoning regulations. I have given repeated representation to the Pollution Control Board and also the BBMP, and I have sought directions from this honorable court.
No, I'm not.
Reply is filed.
Reply is not yet filed, my lord.
Service of notice is awaited. In that to put upon.
On the last, may I make one submission, my lord? On the last hearing date, the counsel appearing for the BBMP had made a submission before the court saying that they are carrying out the activity in violation of the zoning laws, and this honorable court had directed them to produce the records and place it before the court. No such affidavit has been filed today.
We'll keep it early.
Please.
29th.
Please.
65, 66 are urgent. Number 67. It appeal, Mr.
Respondent number 3A, my lord. I'm going to propose respondent number 3A, my lord.
On the A number 1 of 2025, to take out the handsomest to the proposed LRs of third respondent. My lord, I have served a copy on the advocate who is appearing for
I appear for the proposed respondent number 3A, my lord. One respectful submission. I accept notice, but the proposed respondent has undergone heart-related surgery, my lord. I am unable to seek instructions from him. Your lordship may kindly have it anytime after vacation. I shall file my statement of
with kind
objections
permission,
to
my
this
lord.
application.
Let the application 1 of 25 be allowed, my lord. I file an amended petition and I will also bring the LR of third respondent record. My lord, some urgency, my lord. Here, my lord, he has sold the property, my lord. He has no say as such, and therefore, my lord, in spite of, I don't think, my lord, what sort of instruction my letter friend can have from the
My lord, I have no
third
instructions.
respondent.
I have to file my objections to this.
Here is a case, my lord, there is a
Lordship may kindly
playing
have it.
fraud upon the government and BDA, my lord. The deceased third respondent got allotted 1 acre 3 guntas of land in certain 172/2A, which originally belonged to me. Of course, this is a subject matter of the acquisition by BDA. I have lost my acquisition, but here, my lord, it's a case. The third respondent had not lost any property. by playing fraud upon the BTM land, got allotted this 1 acre 3 guntas of land by playing fraud. This is the subject matter of the writ appeal. The learned judge, my lord, without going into the merits of the case, on the ground of low custody alone, my lord, has been dismissed.
My lord, I may.
Next week, my lord, on 2:30, my lord, the purchasers are also on record. They can defend the third respondent's interest.
They have served this application last week, my lord.
4th July.
My lord, please.
4th July.
Please, my lords. Greatly obliged.
Next week, my lord, if it's possible.
There is no such urgency, my lord.
There's no.
Not post.
I may kindly be allowed, my lord. I1.
My lord, I shall file my statement of objections.
I'll let her file. She can come on record. The LR of the third respondent. That's my kindly allow IA number 1 of 2025.
68 is urgent. Number 69. Amrut Chaudhary, yes.
Objections. 16.
My lord, I appear for the respondents. My lord, I have to file objections to the applications. They have filed for production of documents and special leave, and also, please, my lord.
This is the case, my lord.
I
Your
have
lordship may
to-
kindly recollect. They filed a writ petition. They were in the ineligible list of voters. They filed a writ petition. An interim order was passed permitting them to vote. They withdrew that writ petition.
Lord, we were
Later again,
subsequently- we were
another writ
subsequently
petition
pleaded,
is
please, my
filed
lord, we have
for
no-
counting those votes. For
Last
that
occasion,
reason,
we
your
were
lordship had
subsequently
directed us
pleaded.
to implead all of them. Of course, my lord, let my learned friend file it, but if possible, before vacation.
My lord, probably, my lord, may seek 2 weeks time. Why? Because it is only on last vacation, my lord, we came on record and we have filed wakalat.
Immediate reopening. 4th of June.
Please.
Number 70. So Manmohan PN.
My lords, I seek 4 weeks' time to comply with the office objections.
11th July. Before which date the office of objection complied.
Number 71. So furnishing of process fee, etc. Mr. Chandra Kumar R.
In this case, I may be permitted to withdraw the petition, my lord, since the
Which one?
accuser.
Serial number? Number?
71.
Law and Advocate Miss. You are Chandra Kumar.
R. Chandra Kumar. Hello?
You are, what is your name?
DBN, Divya BN.
Where?
Divya BN.
For Chandra Kumar. 6 points. Withdraw. You are withdrawing.
Yes, my lord.
Withdraw the present petition. Dismissed as withdraw.
Number 72. Thomas V. Peter.
72, my lord, sir. Pray for a week's time, my lord, pay the process. Seek a week's time, my lord, to pay the process.
10th July.
You should know this.
Take necessary steps to serve on presence or respondents. So that we come to
Respondents are not, there is no endorsement.
Like the government, my lord, appears for
2 weeks time is granted to serve the respondents.
to take steps to
Serve the unserved respondents. 10.2.
73.
My lords, I appear for the complainant in the matter. It is posted, my lords, if I may make a submission, it is posted for notice to accused number 4. Notice to A4 may kindly be dispensed with, my lords, because I'm seeking compliance from accused number 1 to 3 only, who are served in the matter.
74, 75, 76, 77, 78.
My lords, I'm making my submissions in respect of serial number 73, my lords. My lords, in respect of section, serial number 73,
Yes.
my lord, serial number 73 is linked to serial number 72, whereas it should not be connected, my lords. They are two separate matters. In 73, it is listed for notice to accused number 4. I'm seeking compliance from accused number 1 to 3 only. So notice to accused number 4 may please be dispensed with, my lords.
Yes, next is already dropped.
Serial number 80. My lord, for office
78,
objection
my lord.
second time.
Sorry, my lord, 78 I will make one mention.
Please make
78.
time.
I
For
prefer,
The petition.
4 weeks time is granted.
Your Lordship, in serial number 80,
Give 6 weeks. 6 weeks.
I have filed application for vacating the interim
my
order,
lord.
Your Lordship.
81 same.
Lordship leaves
Since from
serial number
2010,
70.
I have been deprived of the conversion order in the
Urgent. 82 urgent.
Item number 81.
82. 82 urgent. 83.
83 same. 4 weeks
Your
time.
Honor, I appear for respondent in serial number 83, Your Honor. We haven't served the caveat
Lords,
of copy yet, Your Honor.
Start from 84.
81, my lords.
Your
81.
Lordship, may I make a submission in serial number 80, Your Lordship, if Your Lordship.
For sub, it is all dispensed.
No, I have filed vacating application, Your Lordship, since from 2010, my application for conversion is pending. And he has no, the appellant herein has no locus standi and right over that property.
So we have dispensed with the office of this. For the
Your
time.
Lordship, may I request Your Lordship kindly have it in
Not
first week
here,
of
but
June.
in the granted time or dispense with whatever order is there, you see it.
My lord, interim order may be extended.
There is no interim order.
Interim order in 80, my lord. My lord.
In office of decision, now we vacate the interim order till next.
So, my lord, interim order.
84.
In 80.
Council submission on office objections. 84.
Serial number 8.
There can't be interim order when office objection is there.
My lord, we'll comply within a week, my lord.
Maybe complain.
My lord, interim order.
You say more time is granted. Sir.
My lord.
No interim order can be granted. Yes.
My lord,
My lord's permission.
interim
Please
order
sit
is
down.
granted,
No,
my lord.
Nothing doing.
No, next matter, my lords.
Nothing
81.
doing. 84. Yes.
No, my lord.
84. Council submission.
Your Honor, serial number 83, Your Honor. I appear for respondent
Yes.
in this.
Please don't mention. Proceed with 84.
84. Council submission with office objection.
Yes. Anything?
85.
So all will go 84, 85, 86 spread in the first week of June. Up to 89, 90. Which one? Hearing here. Serial number? They are not for office objection. Office objection is up to what? So, this will care for years. So 84, 85, 86, 87, 88. Which is the better heard? 19, 89, 90. So 90, all office objects are for the time being dispensed with. The office is at liberty to list the appeal, whatever it is, etc. For admission, subject to the examination of office objects at the 11th point of 91.
Number 91.
My lords, I appear for appellant in connected matter, my lords. There is an office objection.
Which one?
91, my lord, serial number 91.
91 is not office objection.
My lords, no, connected matter, my lords. In 91,
finally, it is finally.
Connected matter, my lords. 91.1. There is an office objection, my lords, along with council submission.
So,
my lords, the submission, my lord, the office has raised an objection regarding why papers have been produced after statement of objections of respondent number 5, my lords. Those documents were produced by the state before learned single judge, my lord. That is why I have made it as an annexure in the writ appeal, my lord.
So 22nd, Charlie, all 91.
Serial number 90, my lords.
We are not closing the. Why you are all standing up? Just proceed. 92. 91 will go to 22nd.
My lord.
92. Serial number 92.
For the
91
appellants, my lord.
22nd of April.
Number 92, Srimati Ashwini.
My lords, office
For-
objections, my lord.
For, my
Number
lords,
92.
for the
Yes.
appellants, my lords.
Office objections are dispensed with.
Please,
The
my
appeal to
lords.
be listed on 10th of June.
Please, my
Number
lords.
93, so final matter. State appeal.
For
Your
respondents.
All right. When do you want?
Anytime after vacation, subject to.
26th of June, as requested by learned traditional government advocate, Mr. Chandrasekhar.
So 94 is adjourned. Number 95. Pramodini Ranganath Kyar.
None is present. Stand over to 10th July. Okay. Yeah, 95. So this 95. This appeal comes up with endorsement that the officers of which are not removed, though time was granted on 9 occasions. Full stop. It is provided that unless the office of which are complied with within 1 week from today, the appeal shall stand dismissed automatically without reference to or order.
With my lords, leave my lords. My lords, item number 81, I had moved before my lords and my lords was pleased to list it today. The only office objection there was regarding court fees. My lords, I've paid it today. I have paid it today also. My lords, there's some urgency because there's execution which is coming up, and for attachment they're going to order on Saturday. That is why I moved it before my lords, my lord. My only submission is that, my lords, if they let them not precipitate with the execution, my lords, and it can be heard
It
immediately.
is for office objection. No order can be passed. 81. If the office objects are removed, the same may be listed on 24th of
Great, great.
Serial number 90, my lords.
90.
90. Lord, this is a case where the government, my lord, took time. The University of Agriculture Sciences passed a resolution based on your lordship's direction, and your lordship said place the matter before the finance department. They took 5 hearings, my lord, to
Yes, I wanted time, Mr.
for the last 6.
Of 93, what I.
90.
What about 90? So what is the matter?
Sachin VS.
What do you want?
My lord, this is a case where Learned Singha judge directed regularization. Your lordship, my lord, directed the University of Agriculture Sciences to pass a resolution implementing the order passed by the Learned Singha judge. And then thereafter, the matter should be placed before the government for approval. Now, university passed a resolution regularizing. The next part, my lord, is the government has to approve it. They took 5 to 6 hearings. That's the position.
They will take up.
Now
22.
35 years we have put in.
Who is for university?
University, my lord, they passed a resolution.
25 will take up, 25 for.
One submission, lord. 90.3 and 90.4, lord. In this matter, the services have been already regularized and the services have been withdrawn by the university, and they are without salary and all, more than a year, lord. They are without salary, lord. Matter may be taken up at the earliest and maybe disposed of.
All will go together. 25.
25. Okay.
This two.
Serial number 83, my lords, it's for office objections. It's been, everything has been complied with, my lords. There was the only office objections that remained was with respect to court fee, my lords, that has been paid. My lords,
Your
that
Honor,
date will be given, my lords, short accommodation.
Your Honor, I appear for respondent in this matter, Your Honor. We were caveator in this matter, Your Honor. The office people have already informed them to comply with the serving of copy, Your Honor.
My lords, when the appeal was filed, my lords, there was no caveat subsisting. If there was
Your
a
Honor,
caveat
we filed
subsisting, the
caveat
office
even
might
before
direct my
filing
lord.
of
So
appeal,
you
we were on
passed your.
caveat, Your Honor. We filed
List
caveat.
two, my lord, may I seek leave, in list two, may I seek leave to serve the counsel appearing in the executing
Why you do?
proceedings?
There is no order. No order is necessary.
My lord.